of the learned counsel for the petitioner release this matter again on 2nd of March.
2nd of March.
2nd of March. Yeah.
Yes,
sir.
I beg to mention item number 32, Lordship, can be taken up after 1 week, Lordship.
30.
Karma.
At the request of the learned counsel for the petitioner, list this matter again on. Give us a date, sir.
13th of March.
1-3, 13th of March.
Please, Lordship.
Yes.
Item 28. The
28.
petitioner has arrested, Lordship. And I want to order.
It has been submitted that during the pendency of this anticipatory bail petition, the petitioner has been arrested. Therefore, this anticipatory bail is now infructuous. It is closed. Yes.
I beg to mention item number 43 to 45 supply list.
43 to 45. Yes.
This matter may take up after 10 days matter.
Why?
Because on the last occasion we are directed to file additional affidavit matter.
Huh?
On the last occasion we are directed to file additional affidavit matter. That instruction is awaited.
Take some cost and go today.
My
It has been kept as part heard.
Oh.
Now we cannot keep the matters part heard for long. We'll not decide it today. Let the matter reach. Let me see why I had kept it part heard, whether it requires to be released or can we keep it part heard again or not. Yeah. Let the matter reach. Yes.
I beg to mention item number 30.
What? 30.
Lordship. Lordship may kindly take up the matter after 2 weeks, Lordship.
At the request of the learned counsel appearing for the petitioner, release this matter again on 13th of March. Yes.
Your Lordship, I wish to mention item number 31.
31.
Your Lordship,
Ah,
the engaged
hat-trick.
counsel could not be present today to
Huh?
argue the matter. The engaged counsel could not be present due to some difficulty, Your Lordship. So the matter may be listed next week.
At the request of the learned counsel for the petitioner, list the matter again on the 11th of March.
Would it be 6th or 7th? Your Lordship?
6th of March?
Your Lordship, I also beg to mention item number 10, Your Lordship.
10. Huh.
On instructions of the client, we are directed to withdraw the matter.
The learned counsel appearing for the petitioner has submitted that they are under instructions not to press this criminal petition in the present form. Accordingly, this criminal petition is closed in its present form.
Right.
Yes.
Delivery of judgment, public receipt from calculate 24.
কোনখন আজিৰ কোনখন আজিৰ আচ্ছা দিয়ক we have set aside the disciplinary proceeding and given the liberty to the department to take such action in accordance with law if the criminal trial concludes adversely to the petitioner. Yes.
Item 1.
So actually application under NDPS Act under section 20B2C, 29 and 27A. As of today, he is behind the bar for 150 days, Your Lordship. And the Lordship, if Your Lordship peruse the FIR page 12, Lordship will find that nothing has been recovered from the constructive possession of the petitioner and nothing has been reflected herein in the FIR nor in the forwarding as to from whom the contraband has been seized. There are two accused persons. It's very silent. The FIR is very silent in regards to as from whom the though it pertains to commercial quantity of above 20 kg. It is a 21 kg of ganja has been recovered from the co-accused person who was a co-passenger along with the petitioner. They were traveling together in a train. On the way coming back from the station, both were apprehended And as per the FIR has been reflected that
Allegations are there of
818
financing, huh?
financing and also from their position.
CD. Call for the
On
CD.
27 CD is being fixed or fixed
On
together.
27th,
Yes, another matter
it has been submitted by the learned counsel for the petitioner that the CD has been called for on the 27th of February 2026 in connection with
bail application number 23/26.
list this matter along with that matter. Huh?
Item 2,
Application lordship.
Ah,
It's a bail application certificate matter lordship. POCSO is there lordship notice no.
issue notice to the respondent number 2. Call for the case diary. TCR.
Lordship certificate.
Scan copy of the TCR. List again on 20 March.
Can it be on 12th of March lordship?
12th. 12th is too early. We'll have it on 16. 16?
16 is not lordship. March
17?
Lordship on 18.
18.
Possible.
item 3,
Me please, your lordship.
Yes.
Lordship, this is a 483 bail application whereby lordship, the petitioner was arrested on 19/1 and as on date it is 36 days he is on custody.
Ah,
Lordship, the allegation is certain contrabands have been recovered. Lordship, the case diary may be called for.
case diary will be called for.
Called for.
Call for the case diary. List again on. When can you have it?
Lordship on 12th.
12th of March.
Obliged, lordship.
item 4,
May I please, your lordship?
Ah,
Page number 15.
15.
It is registered under POCSO sections,
Hmm.
but there is no allegations of POCSO in the FIR itself. Page number 15, very small FIR, may I read it?
Ah,
With due respect, the main submission is that I am serving at the child welfare office, so and so. On 16/1/2016 at around 1:30 PM, the daughter of accused number 1 and 2 above named and niece of accused number 3, namely so and so, aged about 17 years, visited the office of so and so and informed one of the officer of our child welfare department that 3 months ago she was forcefully given marriage to the accused number 4.
hmm.
By
No,
the-
without notice to the informant, nothing can be done as of today.
As per, so far as Deepak Nayak is concerned, lordship, if it is lordship offences involving POCSO.
Hmm.
So here lordship, even lordship, there is nothing against the.
After you say that she has been given in marriage, are we to presume that nothing happened?
Given marriage by whom? 1, 2, 3 and 5. She said that.
Huh?
Forcefully given marriage with accused number 4, forcefully by the 1, 2, 3 and 5.
Ah.
This is for accused number 4.
Who is he?
PCM is also there lordship.
Huh?
PCM is also
PCM is there, 9, 10, 11 is there.
Child marriage lordship.
Ah.
Prevention of child marriage. So
Okay, who is this? How is he connected?
He is the husband.
He did not exert any force. Issue notice to the respondent number 2. List again on how soon?
lordship on
Whether the marriage took place. When did the marriage take place?
Lordship, marriage taken place on
Okay.
lordship, 27th of December. And another difficulty is that
13, huh?
we have made respondent number 2, the guardian of the victim, as respondent number 2, but he is the accused number 4.
Can I allow you to change it now? You have to withdraw this and file
We
it.
don't have, no, we don't have any option, lordship. As per Deepak Nayak's judgment, we have to make him as a party respondent.
Whom?
The guardian of the victim or victim
Ah,
herself.
the father. The informant.
informant and
The informant has to be made.
informant who?
Lordship, if I am not wrong, lordship, paragraph number 9, it says
Of?
that of Deepak Nayak.
What does our notification say?
Prize the victim, guardian, support person.
Support person. If she is a minor, there must be a support person. Can the accused be?
It can be.
Then we'll have to appoint an amicus directly today itself.
Amicus.
Then you cut out that order. Heard Mr. So-and-so learned counsel appearing for the petitioner, also heard the learned APP. The learned counsel for the petitioner has submitted that the lawful guardian of the petitioner is the accused number 1, and therefore
Mother is 2.
Huh?
Father 1, mother 2.
The father of the alleged victim has been arraigned as an accused number 1. The mother of the victim has been arraigned as accused number 2, and the person to whom the girl was offered in marriage has been
Accused number 4.
arraigned as accused number 4. In such circumstances, he has prayed that he has submitted that issuing notice to the respondent number 2 in this bill petition. Who is he? He is the father, na? To the respondent number 2, who is also the father of the alleged victim, would not serve any purpose. She's from where?
South Salman.
South Salman, Mankachar. We'll have to ask the district legal services to.
There is a list of amicus, Lordship.
No, there is an amicus, but someone has to assist the victim there. I'll let the amicus.
Yes, Lordship. Let the
In
amicus
such
be-
circumstances, this court deems it fit to have Mr. D.K. Bhattach, no, you take in on. Dr. P. Agarwal.
M. Burman is also.
Huh?
M. Burman is also there.
M. Burman is there. Miss M. Burman is the amicus curiae. M. Burman, is the amicus curiae. Then a counsel for the petitioner shall serve a copy of this bill petition on the amicus curiae appointed. Let's this matter again on the 6th of March.
We need to call CD also.
The case diary in the meantime may be called for by the learned VP.
Highly obliged.
Item 5,
8, please, your lordship. 5 and 6, madam, may be taken up together, madam. Same FIR. Whatever, madam, 5 is the owner of the vehicle, madam. It was carrying beetle and areca nuts. And item number 6 is the owner of the areca nuts, madam. Now, madam,
Now 5 is who? 5 is
5
the?
is the owner of the vehicle, madam. Owner of the vehicle, and 6 is the owner of the areca nuts. Madam. And madam, FIR at page 13, madam, of item number 5. Page 13. Actually, madam, some areca nuts were seized, madam, and in the FIR itself, it is suspected, madam. It is suspected. Madam, the word suspected is there in the FIR, madam. Now, madam, at that time, the driver could not provide the valid documents, madam. That's why it was seized. But, madam, if item number 6 is taken, madam, I have madam, annex all the relevant documents from where it was purchased. It was purchased.
Where?
Item number 6, madam. It is item number 6, madam. From Moirabari, it was page 15 is the seizure list.
How is it recognized that this is the beetle nut from Moirabari?
And at the outset, I'd like to say, madam, that I have paid the GST bill also, but madam, there was a delay in paying the GST bill also, madam. If lordship permits, I'll produce everything. GST bill also I have annexed, madam. I have GST registration, everything, madam. I'll produce the documents, madam. If lordship protects me, madam, I'll produce the document and madam, the investigating agency may verify whether these documents were.
This e-way bill is of 18 to 2026. From Moirabari to
Moirabari Botpet.
distance of 244 kilometers. Yes, what do you say, Mr. Goswami?
At the time of lordship, he failed to produce the documents. So
The driver. Owner was not there.
Yes, lordship.
But if he appears, gives you the documents, if the investigation progresses, if the beetle nut is not identifiable to those documents,
Produce the documents and then.
till then, let him produce the documents. Have your verification done if it is of the same beetle nut? If yes, and if not, then also consequences. If it is not the same beetle nut,
Case date will reveal also.
that will reveal. Third, Mr. Swensol and counsel appearing for the petitioners. Now, in item number 5, in AB 391 of 2026, the petitioner is the owner of the vehicle, which was allegedly intercepted while carrying suspected betel nut from Burma. The learned counsel for the petitioner has submitted that given the option, he would be in a position to appear before the investigating authority and prove the validity of the transaction undertaken by the petitioner. Full stop. This court is also of the opinion that appearance before the IO would help in progress of the investigation. The petitioner is directed to appear before the investigating officer of the case on or before 6th of March 2026 to participate in the investigation process. If he is arrested in the meantime, the petitioner shall be released on bail of rupees 10,000 with one surety of the like amount. So to the satisfaction of the investigating authority, list the matter again on
23-3.
23-3.
He failed to produce the origin documents and then
It is however provided that in case the IO is not satisfied with the documents produced by the petitioner, the same shall be revealed in the case diary for further consideration by this court. In item number 6, you say the petitioner in this bail petition is the owner of the suspected Burma beetle confiscated by the police, which has been seized by the police on so and so date. On when was it seized?
On
15/2/2026. List of the learned counsel for the petitioner submitted that the petitioner has got appropriate documents to show the legality and validity of the transaction being undertaken by him to transport the betel nut. This court is also of the opinion that appearance of the petitioner before the IO at this stage would facilitate the investigation. Therefore, the petitioner is required to appear before the IO on or before 6th of March. List this matter again on 20th of March for updated case diary. In the meantime, if the petitioner is arrested, he shall be released on bail of rupees 15,000 with one surety of the like amount subject to the satisfaction of the IO. Full stop. The case diary the IO would inform this court as to whether the documents produced by the petitioner have relevance to the commodity seized during the commodity seized.
Item 7.
Yes.
Sure. It's an anticipated bail application under 482 DNSS. Basically, the FIR is in page 18 to 21, Your Lordship. It's a huge FIR. So basically what happened in this particular case, one was the main accused, that is Sri Navajyoti Deka, who was arrested, and thereafter he was granted bail by this Honorable High Court on 27/8/2025. Annexure 2, that is 22. Page 22 is the bail release order. Order of this, he was granted bail. And other number 2.
Same FIR. Same FIR.
Same FIR, Lordship. There are three other persons: Shanti Sharma, Bidu Charji, and Dilip Lokkar. Basically, they are of apprehension of arrest. They are in apprehension of arrest, and so the anticipatory bail application.
Why do they apprehend arrest? Because they are.
Because the informant alleged that these three accused person were helping the main accused, that is accused number 1, Navajyoti Deka. The main allegation was that they were having a mutual love relation, Your Lordship. And then the informant alleged that the accused Navajyoti Deka falsely promised her to marry, and thereafter they established certain physical relationship. And it was going on since 2013. Since 2013, and thereafter also there was allegation that the Navajyoti Deka, the main accused, also attacked her several times in order to attempt to murder her. But
But here at page 18, we find accused number 1, then 5, 6, 7.
yes, Your Lordship, actually it is printing mistake, Your Lordship. It
Oh.
will be 2, 3, 4.
Yes, what do you say?
Page 20, paragraph 1. Only thing is that, Lordship, I pointed out.
Page 20.
Page 20,
Hmm.
the FIR, Lordship.
Huh.
The accused number 1 invited accused number 2 and 3. His home, accused number 1's home, Lordship, as a caretaker, and I suspected an illicit relation between accused number 1 and 3. Accused number 2 also cooperated them.
Just a minute. Where do you say? Where do you?
Page 20, Lordship. First prayer, last person, Lordship.
The accused number 1 invited accused number 2 and 3
That is the
to his home as caretaker and are suspected an illicit release between so and so, so also cooperated with them.
Mayor allegation, Your Lordship.
Art Miss so and so, your name?
J. Das, Lordship.
Miss J. Das, Learned Counsel paying for the petitioner, also heard the learned APP. We have gone through the contents of the FIR and also have seen the order dated 27/8/2025, passed in bail application number 2585 of 2025. The allegation against the petitioners hearing is that they had cooperated with the applicant in BA number so and so when the informant had been allegedly put to harassment by the applicant in BA number so and so, full stop. On a perusal of the FIR and also the orders passed in BA number 2585 of 2025, this court does not deem it fit that the petitioner 1,
Petition 2, 3, like 1, 2, and 3.
the petitioners herein namely so and so, so and so, and so and so would not be required for custodial interrogation in the case, full stop. Accordingly, it is directed that in the event of the arrest of the petitioners, they shall be released on bail of rupees 15,000 each with one surety of the like amount subject to the satisfaction of the concerned IO. Full stop, the petitioners would appear before the concerned IO on or before the 6th of March to participate in the investigation. Bail applicant AB disposed of.
Deeply authorized.
Or admission. Item 8.
এটা কি এই
Something instruction will call for this case.
With due respect, can this matter be taken after some time?
after sometimes
Lord.
হেৰি কৰক নেকি এই ক্ৰিমিনেল মেটাৰখিনি মাতি লওক নেকি we'll finish the criminal board first. We'll finish all the criminal first. Admission to পিছত নহলে এবাৰ ৰিটত সোমাই গলে আৰু এইফালে মুটো নুঘূৰে
Bail hearing began, item 12.
I'm appealing for the victim, you know.
Here, my lord, 17 years, my lord, girl, and 20 years boy, my lord. There is a love affair.
yes CD is awaited, sir. CD is awaited.
My lord, this is for third time, I think, my lord, and already.
We'll impose a heavy cost on the police
My lord, 80
for
days,
not sending the
already
CD.
almost 80 days in custody.
I
my
will
lord.
impose some cost.
My lord,
When will you have it, sir? Admitted love affair and 17 years.
and affair itself reflect, my lord, there is a love affair.
But then you are not supposed to go and misbehave with her on the road, are you? Huh? The client should not do that. When, sir?
Lordship. Already almost 80 days, madam. In custody. Madam. Custodial detention may be considered, madam.
Up to 6 is there, Lordship. Up to 6 is there, Lordship.
Ah,
He has been harassed, Lordship.
ah.
Lordship, let the CD come
That is what, when?
day after tomorrow.
Day after tomorrow. Okay. At the request of the learned counsel for the at the request of the learned APB, release this matter again on 26th. 26th.
27.
27th of February. Friday.
Friday.
Today is Tuesday, Friday.
Okay.
Mr. T. Deuri, Learned Amicus Curiae, is present. Mr. Swenson, Learned Counsel for the petitioner.
Obliged, madam.
Item 13.
May I please?
Ah,
My friend is supposed to obtain instruction regarding service of notice.
of
It is
Respondent number 2.
complete. Service is complete.
service is complete, none appears.
None is, Lordship. Yes, none is there. On
Yes, sir.
16th, it was completed, Lordship.
Ah, quite some time. None appears for the respondent number 2, though the service has been shown to be complete upon the said respondent. Accordingly, Dr. Gaurav Jyoti Sharma, Learned Counsel, is appointed as the amicus curiae to assist in the matter. The Learned Counsel for the petitioner shall ensure service of copies of the bail petition on the amicus curiae appointed to assist in the matter.
Monday.
Release the matter again on Monday, 2nd of March. We have the TCR is here.
They will serve the copy tomorrow.
On the amicus or on the U?
Today, my
Yes.
14.
14.
Lordship, this is the case
Ah,
where a firearm was discovered in a garage, Your Lordship.
ah,
Your Lordship had called for a report.
yes. Is it a firearm?
Lordship, that report is still pending.
Eh?
It has been sent for FSL, Lordship. To the FSL Forensic Science Laboratory, Lordship,
Ah,
to ascertain whether it is a firearm or not, Lordship, whether it is serviceable and so on, Lordship. That report is still pending.
Lordship is already in 40 days detention, Your Lordship. 7-year punishable offense. And plus, it says found in a hidden concealed box in a garage, Your Lordship.
garage is yours.
It is his.
Garage is yours.
Your Lordship we cannot say who works there, who does not.
Eh?
Two other persons who work there.
Tell us who worked there, who is the welder there. Give us the name of the welder, we'll focus on him.
No, their statement has been recorded, Lordship.
Ah,
They know nothing, Lordship. Ownership on the owner, Lordship. Let it be listed after 10 days, Lordship. In the meantime, we'll try for the report also.
Otherwise, Your Lordship can consider. He's only 23
Huh?
years old, Your Lordship.
I understand.
That could be very old. He's
I understand. That is at that age he should not be.
It may take a long time for the CFSL to determine also. They have much bigger cases to deal with anyway.
See, it was not on a routine search that they had found it. It was on specific information. That creates a trouble. He must have been wielding it to someone. Someone noticed it. Specific information in the FIR. That is what we are trying to see. If it had been a routine search, stolen rods and this thing was searched and suddenly we noticed, then it's a different issue. But otherwise, we'll have it on the 5th. Can you have it by the 5th or 6th? 6th. 6th. List again on the 6th of March.
6th, Lordship.
Tell us. Tell us. Any difficulty?
Your Lordship, just before the statutory period.
Oh. Then we'll have it on the. Prior to that, will a report come?
Won't come.
On the 2nd?
Won't come, Lordship.
Huh?
It won't be issued.
The only thing we have in mind is being a welding shop.
Yes.
The shape might be there, the functionality might not be there.
Second,
Yeah, because at that age, we have seen people have a tendency to show off rather than utilize. Age of 23 is something where you show off, you don't utilize.
this statement which he has given, it doesn't inspire at least my confidence.
Okay, we'll have it on the second. We'll try. Try for the second, whether it is functional.
Second,
Huh? It is taken on the 2nd of March, allowing the learned APP to have his report on whether the item recovered is a functional firearm.
pleasure.
May I please, my lord?
Yes.
Case related to NDPS, my lord, 21B and 27A, my lord. CD, my lord. Short date, even then, my lord. 125 days.
Huh?
125 days.
6th of March.
180 days is the mandatory.
So when do we have it? Tell us.
He did of 27A, my lord.
That will be revealed from the case date.
When can we have it?
9th of March.
9th of March. 9th of March, huh? Awaiting the CD.
My lord.
Petitioner has completed around 125 days in custody. We'll keep a note of that so that you can send it.
Lordship, on behalf of Mr. Estelicious, I'm praying for the time being.
The CD is awaited, sir. CD is awaited.
Not CD, Lordship, the service report is awaited.
Or service report is awaited. Sir.
Is awaited.
POCSO matter. POCSO.
Lordship, I'm praying for the time being.
Time being. Okay. We'll pray for we'll wait the time being.
Supplementary item 46.
May it please, your lordship.
Hmm.
The commercial quantity was involved,
Oh.
but during the last hearing, the learned PP said that another case was there in regard to which I was shown arrest. So I have filed this additional affidavit, bringing on record those facts. At 47, 48.
Additional affidavit, sir.
Yes,
When did you file it?
yesterday.
It's not here.
It was called for yesterday.
It was called for yesterday. It was not here. So soon. Ase niki? Ne upor lagai thise. Add 2 kori diok. Add 2 kori diok. File kon sai lobo diok. Eikon ase niki? Diok. It is here. Here.
Otherwise, out of 7 PWs, 3 examined.
All 2 of them hostile, and one said that I don't know what are the contents of the powder.
And next date is 21 to 26, which have already gone.
Gone.
And the teaser witness part that is already over. And this affidavit, your lordship may come to page 43, para 2. I'll read para 2. It starts with that the present affidavit has been necessitated to be filed in view of the fact that certain important factual aspect regarding the petitioner's detention in connection with Badarpur PS case 302 of 2024. This is the earlier case. In special NDPS case 130 of 24 could not be brought to the notice of this honorable court by the deponent by way of the connected bail application, as the same was not within her specific knowledge.
But apparently this man is involved in so many cases.
Yes.
But this arrest, this was an illegal arrest because
Could be because of a technicality. The involvement cannot be.
but
Even Mihir Rajesha says that if the technicality it goes, you can be rearrested complying with all the technicalities.
but if we go by the merits also, if your lordship goes through these 3 evidence,
That is what is feared while giving a bail, that everything will be manipulated. People will turn hostile. That is the whole issue, is it not? He will not interact with the witnesses. He will not dissuade anybody. Don't we say so?
and there are very bleak chances of conviction. Very bleak chances of conviction. Considering that
No, the thing is that this conviction not coming on is allowing him to roam free may create a trouble.
And the shown arrest order also,
Hmm.
your lordship will find at page 46.
Hmm.
There also, before showing me arrested,
You were not given any information why it was done. Yes, we understand that.
Lordship, 37 number is there also.
Huh?
Satisfaction of lordship, 37 lordship.
fundamental right will override.
By the way, the witnesses are going, conviction is,
That part is a-
so 37, you see, that part is coming down. Chances of conviction. Is it not?
Otherwise,
But his involvement in so many cases. He was granted bail in one, shown arrest in another. There is another case pending before this court.
No, two cases were there.
Huh.
The earlier case, I was shown arrested. There, while I was arrested on production on this, in this present case,
Huh.
I was granted bail in the shown arrested case. So two cases are there. This NDPS 130 of 2024.
You were granted bail by which order? Can you show us?
By the order dated 21/5/25 at page 47.
This is the case where you were shown arrested.
130 of 2024. The present case is 130.
So in the shown arrest case, you have been granted bail.
Yes,
Huh?
yes. The earlier case I was granted bail.
In the shown arrest case. Now he is hearing the other case.
The new case, next case, 135 of 2023. Your lordship may read from the last para, page 47.
We read it.
47, no? Page 47.
Huh? You are a resident of where?
I'm a resident of
Karimganj.
Sribhumi. Ratabari, Sribhumi.
only thing lordship, I'm humble prayer before lordship that he's no doubt he's an habitual offender. Lordship will consider only these things that only because of the society will concern in this case. Granting him bail and again he will harm for the society also. Lordship. Fundamental right is there. That is, we are never doubt on the other. This reward will be bail. Lordship. The only thing is that this.
Why such a tragic? Well.
And another point is regarding the incarceration also.
Huh?
Yeah, the incarceration in the prison.
Huh.
Been incarcerated for 340 days till date. And the Supreme Court says that where the prosecution does not take steps to speed up the trial, then they should not raise any objection.
And that lordship, I have charge framed on 13/6/25. So out of 7 PPW to examine already.
Huh?
So trial is going on fair and regular manner. Lordship.
And that part we are not doubting.
Lordship.
Your efforts in the trial, the prosecution's effort in trial, we are not doubting.
But the quality of evidence, that is another thing.
Eh?
The quality of
That
evidence.
is to your advantage.
Evidence.
Where is your arrest memo?
Arrest memo regarding the previous case.
Huh?
The previous case, arrest memo was annexed at page 50.
5?
50 of this additional affidavit, your lordship.
No, this case.
This case, there is no arrest memo.
In bail application 188 of 2026.
Yes, there is no arrest memo. Here also similar session, no ground of arrest, nothing.
How were you arrested?
That order
when?
is annexed at page 46.
No, this present case we are talking of.
Present case.
There are two cases.
Yes.
In one cases you have been granted bail, that is
130.
130, and this one is?
This one is 135 of 2020.
135.
135.
Now, can you show us something about 135 we are asking you?
130.
One where you have been granted bail, we are not concerned with that. Someone has granted you a bail.
Yes.
What about this one?
Here I have annexed the evidence only.
Not the other part of it.
Regarding the arrest memo, those things are not on record.
When were you arrested and what is your age?
21/3/2025.
21/3/2025. Not a very happy situation.
In the PCR also, Lordship, only the rest when the 47, 48 on the ISR Begum, these persons.
In regard to the co-accused who have
Co-accused.
implicated me.
Who implicated you?
Yes.
But while arresting you, nothing given.
Documents is not in here also. So I think it has shown arrest. That's why the.
That's why nothing has been granted.
I don't know. Have been
No, no, there are two cases.
Yes, but that part is not in the.
There are two cases.
Yes.
One where he was actually arrested. One where he was shown arrested. Shown arrested, he has been granted bail. One where you are actually arrested is before us.
That part may be called for Lordship. Otherwise, in that scan copy Lordship, that is not in here.
That your lordship will not find that arrest memo and all. Because
In the first case, in the case which is before us, 130.
135.
Now 135, it is not there.
Because what happened on the earlier dates, the court have issued a bailable warrant. So I did not appear. So later on 21/3, on the basis of one production warrant, I appeared and I was shown arrested. Your lordship will not find anything more.
I'm still.
That part may be called for Lordship. Otherwise, if not available, Lordship,
We are trying to understand this is a man's liberty. We are taking time. Nothing else.
Lordship.
Tell me one thing first.
What?
There are two cases, 130
130
and 135.
and 135.
Correct?
Yes.
You were arrested in 135.
I was arrested
Physically.
in 135. Yes. Yes.
Right? So when you were under arrest and in custody,
Yes.
you were required, you were
I was arrested in 130 earlier.
130.
Yes.
Okay, then
Then I was in the custody, and in regard to this case, 135, bailable warrants were issued by the
but
court.
you were already in custody
But I was already in custody
in 130.
since 12/12/2024 in 130. So later on 21/3, on the basis of a production warrant, I was produced before the court. Then the court came to know that I was already inside in the 130 case. So thereafter, I was shown arrest in this case as on from 21/3/25.
On in 135.
In 135.
And then in 135, you have been given the bail.
In 130, I have been given the bail subsequently.
Why?
Your lordship will see.
So you are now only under, you are in arrest only, you are under, you are in custody only with regard to 135, where you were shown arrested.
Yes. Yes.
On 10/1/25, Lordship, the PW issued against accused Kamrul Islam not returned at fixed 20 production and 7/5/20.
No, he was in
I was in custody.
he was already in custody. How could he be? Is it not?
I have stated that in the affidavit as on 12/12/24.
Now, but tell us this: when you are showing, when you are showing arrest to someone, Mr. Goswami,
Lordship,
when you are showing arrest,
that is that part I have.
is the person not supposed to be told that we are going to arrest you in
Yes,
that case also?
But in the
Where is that order?
in the scan copy, Lordship, the order is
You have to look into the TCR of 135.
yes, 135.
There must be an order that he is shown arrest in this case also.
There is one decision to that extent passed by this honorable court.
What?
That in regard to shown arrest also, this grounds of arrest has to be complied.
On
Sure.
on 21/3/25, Lordship, accused Kamrul Islam is physically produced before me for jail custody and a strength of production warrant issued against him. Issue custody warrant, that is
Para 7. The counsel for the petitioner further stressed his argument on the point that petitioner was also shown arrested on 4/10/24, but no grounds of arrest were communicated.
in the notice served upon him under section 50 of CRPC 47, and no due notice was served to his representative under 50A CRPC as well as 22(1) of the Constitution of India, and the same has been held to be mandatory by the Honorable Supreme Court, which held that the arrest of accused is invalid under such circumstances and on these grounds.
Para 15.
Then para 15. Whether the person shown arrested in connection.
17. 15 and 17.
Then 17.
His shown arrest goes.
Yes.
Huh? Unless you can show us something. Shown arrest on?
Shown arrest on 21/3/2025.
Look at that order, 21/3/2025.
Order.
All this time, he never knew he was shown arrest in some other case.
Yes, here in the order of sheet. Accused Kamrul Islam, who said is physically produced before me from jail custody, strength of production warrant issued against him, hard issue custody warrant.
So simply on that basis.
Needs to go. We'll keep this.
Notice. Not on this 21/3/25. It is 21/3/25 order. Not a single.
That he was told that he would be required to be arrested in this case also.
Single.
Something, one sentence.
Yes, one sentence.
That is a magistrate. Heard, Mr.
As the
Learned counsel appearing for the petitioner also heard Mr. D.P. Goswami. The case of the petitioner in this bail petition, paying for bail in connection with
135 of 2023.
In connection with from page 1, so and so, is that the petitioner had been arrested in connection with what is the other case?
The old one. Special NDPS 130 of 2024.
2020. And by an order dated 21/3/2025 passed by the learned whom?
Session Judge Sri Bhumi.
Additional Session Judge Sri Bhumi. Come on. The petitioner had been shown arrested in connection with this present case, full stop. The learned counsel for the petitioner has submitted that in connection with special N case number 130 of 2025, where he had been earlier actually arrested, the learned court of the Session Judge Sri Bhumi has already granted him bail on the ground that the provisions of section 47 of the BNSS had not been complied with. In the present case, the learned counsel for the petitioner has submitted that while showing him arrest in connection with special case number 135 of 2024.
Special case 135 of 2023.
23, the petitioner was not given an option. Was not given the information as to the grounds of his arrest while he was being shown arrest, full stop. He has referred to the orders passed by this court on 27/3/2025 in bail application number 3519 of 2024 to contend that non-informing the grounds of arrest to a person even while showing him arrest in connection with other cases would be a ground to hold the shown arrest to be illegal, and the detention thereafter has to be necessarily interfered with by this court, full stop. Mr. D.P. Goswami has submitted that in a case of shown arrest, the grounds of arrest may not be required to be submitted separately. Full stop. The provisions of section 47 of the BNSS reads as follows. Take from page 5. I have rounded it. The provisions of section 48 BNSS thereafter also provide. Okay. Then take para 13. Then you say paragraph, then you say from the records of the special case 135 of 2023, comma, it does not reveal that the petitioner was at any point of time reveal the grounds of him being shown arrested in that particular case. Full stop. In such circumstances, going by the settled principle of law that an arrested person must be informed of the ground of his arrest and detention, comma, this court is inclined to grant bail to the petitioner. Accordingly, from para 24 of this earlier order, these grounds will suffice. Yes, these grounds will suffice. Be disposed of. Yes.
Please.
Huh?
Please, Lord. This is regular bail application.
Hmm.
Lordship, but this is one test intestine, Lordship, and they recovered from the possession of the petitioner, Lordship.
And
that is his for consuming, he is carrying this Lordship for his own consuming. And FIR will find Lordship, page number Lordship 9, Lordship. As on today, Lordship, and 27 days in custody, Lordship.
We have not received the
Intestine.
Yes, I not received.
when were you arrested?
I have been arrested on 28/1/2026. As on today, 27 days, Lord. Now, as Lordship,
He admits.
Yes.
He admits it is beef, but he says that I'm carrying it for consumption because it is thrown out from the slaughterhouses in Meghalaya.
Hahim, Lordship.
Huh?
Hahim adjacent, Lordship, Boko.
Hahim. No, I heard Kandim. Huh?
CD is available also.
CD is available. Custodial interrogation required. The CDS call for has been received. Heard Mr. And also heard Miss for the petitioner, and also heard Mr. B. Sharma, Learned Counsel, Learned APP. The contents of the CD does not reveal that the further custodial interrogation of the petitioner is necessary. You are a resident of where?
From Boko, Lordship, 28/1/2026, from Boko PS, under Boko PS.
In the circumstances aforesaid, this court is inclined to grant bail to the petitioner. Accordingly, it is provided that in the event the petitioner can submit a bail bond of rupees 15,000 with one surety of the like amount. Huh?
DMFC Boko, Lordship.
To the satisfaction of the GMSC, Boko,
Boko.
he shall be released on bail. Stop. Subject to the bail shall be further subject to the conditions that the petitioner shall not indulge in similar activities.
Lordship. Deeply obliged. Obliged, Lordship.
Disposed. Carry something that you can eat. Don't carry something which raises suspicion. Is it not? 20 kilos, 30 kilos, who can eat?
It is not for.
Yes. Yes, sir.
And also, this application, office note indicate that I do not know whether it was start.
Service report is awaited, sir.
But this is the second day. Amicus may could you may appointed, but because I have already completed more than 134 days. Adults and consensual sex, my lord, they are living together.
They are living together, Lordship, then what is the difficulty in making the service, Lordship?
I am inside the jail, that's the problem.
She is living where?
She's out in my home,
In her home or in your home?
my home.
In your home. Then we can have it served through someone in your home. But she's a minor.
In the last occasion, they made a statement that they are married.
Yeah, still we are married, I am saying.
He is inside, she is in his home. They are married. He's not denying that.
But POXO is there, that is the problem.
What is her age?
Now, of course, may little bit 17 years, 3 months at the time of occurrence, my lord. My lord, there are cases, my lord, may I be permitted to press?
No, but we can consider the thing if we can put up a amicus at least.
Yes.
Is it not?
I think it is
Mr.
better.
Sharma?
It will follow the formality.
Hmm?
The requirement of law is there.
Let amicus be appointed.
Those steps were taken on
Steps we have taken.
when? Those steps were taken on 9/2/2026.
Thereafter we have taken.
Hmm?
I have taken steps, my lord.
Ah. And the scanned copy of the TCR has been received, comma. The service report has not been received by the registry till date on the respondent number 2. Full stop. In these circumstances, this court deems it fit to appoint Mr. A. Fukan, learned counsel, as the amicus curiae to assist in the matter. The learned counsel for the petitioner shall ensure service of a copy of the bail petition upon the learned counsel, learned amicus. Place this matter again on 5th of March. 5th of March.
Little earlier, my lord, if possible.
Mr. Biswas, 3rd and 4th is closed.
5th, if possible, 5th,
Huh?
5th of March.
5th of March.
Yeah.
We said 5th of March.
Right.
5th of March.
Item 17 to 19.
May I please, Your Lordship? Anticipatory bail application, my lord.
Ah.
I am in item number 17 and 18, and my friend is in 19.
However, in this case, Lordship, before my learned friend start Lordship, one this Prasenjit Hazarikas, Purabi Pathan, they are on interim. Their statement I have not found. Other person statements are there. So kindly fix up another date for updation.
No, not required. In fact, it is a covered case, my lord. One application has already been disposed of. One application has already been disposed of, arising out of the same FIR, my lord.
Are we trying to assume that this is a writ petition where it will be a covered case?
No, my lord.
Every accused will have his own role to play, sir.
I don't mean
Huh?
that. Lordship will see the, my lord, order.
ATM.
Yes.
Everyone has his own role. One will
I
be
will
before
refer
the
to-
camera, the other will be trying to convince the person, third will be trying to find out the password. Huh? So the person before the camera, he's only trying to hide the others. Two people are trying to take out the money. So
Yes, Lordship will take the next page 2, my lord. The relevant person will be there. May I read, my lord?
what had happened? More money was withdrawn than.
No, it was mechanical error, my lord, machine error.
No, what happened?
Ultimately,
Out of the error, what happened?
DP was closed, my lord, eventually. And my lord, there was no such result.
No, these persons, they are from the bank. They are bank
They
officials.
were officials.
Okay.
At that point of time, whoever was posted there, my lord, against all those persons, my lord, FIR was lost.
Saying that they had taken away the money or they had
No,
not put in the money.
No, not like that. It was purposefully filed, my lord, FIR to get the insurance benefit by the bank. And in fact, the regional officer, my lord, himself observed, my lord. That observation is also recorded in the order, my lord. Malfunctioning of the ATM. Next page, 3rd page itself, my lord. 3rd page of the order, my lord. It appears from the materials on record that with regard to the malfunctioning of ATM machine, the superior officials of the regional office, after due verification of the ATM machine and after loading cash in the ATM machine, took away the ATM machine keys with them for verification and rechecked the machine on the next day. And the same problem arose, my lord. Machine
Yes,
itself was malfunctioning.
Why do you want the custodial interrogation now?
Yes. And in
Whereas
fact,
the other person statements are there.
and lordship may kindly see, Lord,
The petitioners, give all of them together only. Heard Mr. M. Fukan learned counsel appearing for the petitioners in AB number 704 and 686.
my lord.
And Miss appearing for the petitioner in AB 869. 2025, the petitioner had been granted interim protection to appear before the investigating authority to have to participate in the investigation process. It is stated that all the petitioners have appeared before the IA and participated. The learned counsel for the petitioner has submitted before this court an order dated 23/10/2025, passed in AB 730 of 2025, arising out of the same FIR, in which it has been noted by this court that the funds which allegedly did not tally had happened due to a mechanical fault in the ATM machines and not due to misappropriation. Full stop. Keeping all the above in view, this court is of the opinion that the petitioners can be granted, that the privilege of pre-arrest bail granted to the petitioners on the earlier occasions can be made absolute. Accordingly, the earlier orders granting privilege of pre-arrest bail to the petitioners are hereby made absolute. Anticipated bail petitions are disposed of. Wow, what I thought was that they were the persons who were clicking the thing, taking their ATM card,
There is actually.
hiding the camera, huh?
There is actually the amount is smaller than the amount that should be lodged.
No, it was
Accounted.
It was
account is
mechanical.
wrong
It was
because of the ATM lodge.
mechanical fault.
Mechanical.
The counting was wrong.
Okay.
The machine counting was wrong.
Machine counting.
Item given 20 CD not received. Petitioner is on interim protection list again on the 20th of March. Interim protection continues. This March.
Lordship, item number 21 are same.
Same.
Same lodge.
Same order, huh?
Not available. Lodge. 22.
CD not available.
But I think.
The petitioner is on interim protection list again on 20th of March, 20 March. Interim protection granted earlier continues, huh?
After 23.
After 23rd. You have it on 27th?
Probably.
23.
Yes.
But diary was called for along with injury report.
Yeah.
Lot
Have you appeared?
Injury report is there,
Ah.
but two of the persons injury report is simple. However, other persons it is stated that X-ray advice for X-ray. So
You-
it was not stated. Lordship.
They have appeared before you. They have told you
Your lordship.
in which manner they have made that hit.
Lordship.
Do you need their custody now?
No, otherwise not. Lordship. But otherwise the statements are not the only 2% I have found. Lordship may.
They must have appeared. All appeared.
All appeared.
We'll record your statement. The learned counsel for the petitioner has submitted that all the accused have appeared before the investigating officer in pursuance to the liberty granted by this court and have participated in the inquiry in the investigation proceedings. Full stop. The learned APP has submitted that only statements of only two of the accused are available on record with him today. Today it is only two are available.
No, only 2% statements are available. Lordship.
Huh. The statement of only 2 persons are available with him today. Full stop. In view of the matter that the petitioners have appeared and cooperated in the investigation process till now, this court deems it fit to allow to make the interim protection granted to the petitioners absolute. Accordingly, the said is made absolute and interim this AV is disposed of. Petitioners oblique accused would appear before the investigating officer as and when called for, and any default would be a ground for cancellation of the bail. Yes.
Yeah, this is a POXO case, but I have not received notice. Since this is a POXO case also.
Lordship,
But he is on interim
interim lordship, against our no POXO allegation is there, lordship.
against you.
Yes. lordship.
Against him, there is no POXO.
15 lordship.
Against the petitioner,
There are 2 accused lordship. One is
I
another.
apologize for that because notice has not issued. I have not looked into that CD.
there is no problem. We'll just take a reading. We can read it once.
My petitioner is
Minor
two
daughter
lords.
so-and-so was accused number 1.
Accused number 1
Told
is
her-
my son. Here
Huh?
petitioner is the accused number 2 lordship.
Oh, the father has been accused only because he refused to listen to the victim girl's father.
ও খালি গালিগালাজ করে ঘরের পর খেতে দিই। Only this is the only allegation against me, lordship. And I have appeared before the IO already, lordship.
He has appeared. I have seen lots.
He has appeared, no?
He has appeared. His statement also recorded lots.
Do we need him in custody, no? Do we need him in custody?
But I have not read lots, so I have.
The service report on the respondent number 2 is awaited. The petitioner is on interim bail. List again on the 5th of March.
Lordship.
Awaiting service report on the respondent number 2. On that day, we'll appoint an amicus and we'll dispose.
Amicus may be appointed. Lord.
Amicus may be-
Not today.
Not on
We'll await it till 5th.
Lordship.
If on the 5th none appears or the service report is not there, we'll appoint an amicus.
Take instructions regarding service, lordship.
No, I have taken.
They always do.
25.
Wait, please, Your Lordship.
Yes, sir.
Lordship, kindly have a look at page 9, the FIR matter.
Page 9.
Page 9 matter, a
Huh.
small FIR.
Oh,
25.
Hmm.
Now, Your Lordship, may kindly turn to, my lord, page 3, my lord, paragraph 3, my lord. I have narrated the fact, my lord. May I read, my lord?
Hmm.
The petitioner begs to state the fact of the case is the victim who resides in village Madhyam Nagar and the police station Mikirbeta went to the house of the accused who reside in village Borbari under Lahorigarh police station. On 5/9/25, when she reached the house of the accused petitioner, the father of the petitioner immediately taken the victim girl to the Lahorigarh police station, and thereafter the police person of the Lahorigarh police station handed over the victim to the family on the same day. It is pertinent to mention herein the victim girl had love affair with the petitioner who is aged about 19 years old. And next page, my lord, paragraph 4, my lord. So the petitioner begs to state that the informant and the father of the petitioner came to an agreement that the daughter of the informant will get married with the petitioner as and when she attains the age of majority, my lord.
okay.
My lord, I have annexed one affidavit also, my lord, page 15, my lord. 16 is the operative part.
Yes, sir. What does it say?
Yes, Lordship, her statement has been recorded and recorded, Lordship. May I just point out on 16/9/25, some sections has been added. And if Lordship kindly takes up the BNSS for a moment, Lordship.
এখন কোট আছে দিয়কচোন BNSS section
Lordship, here, Lordship, this is anticipatory bail under 482. So Lordship will kindly take up 482, section 482.
Hmm.
482, Lordship will see direction for grant of bail to person apprehending arrest. Lordship will kindly come to subsection 4. Nothing in this section, Lordship is found it.
65.
65. Here, Lordship, 65 has been added, Lordship.
Why? Will simply adding do what is 65? Let us also see 65 for a minute. You have received a CD.
And Lordship, this bail application was filed on, I'm not sure, in the month of January, probably, I'm not sure. Whereas this section was added in the month of, Lordship, September. When 16/9/25, to be precise. Added sections were added on 16/9/25. And this bail application was filed, anticipatory bail application was filed in the month of January. This.
So would you like to verify?
My lord, I have made the informant as a party, my lord.
Ha.
I think they appears, my lord.
No, that is there, but the FIR which has been annexed to this
Yes,
bill
sir.
petition, this certified copy apparently has been taken on Very interesting. When? Those pages are not in this code. Now, if that added section is there, should it not be brought to the notice of the court?
Now my friend has taken the plea, my lord. The section 65 has been added, my lord.
And that is prior to the filing of the bail petition.
Yes, my lord. Now the question arises, my lord, whether from the CD, whether my landed friend can say that rape has been committed. My lord.
That is another part.
But
If the section has been added,
yes, my lord.
should it be
Say-
before the court is the issue? If it has been added,
Well.
whether that is for us to take an opinion,
Yes.
whether the materials are there too, or whether we can grant you bail or not.
Yes,
That is for us to consider.
Yes, my lord.
And we have always listened to every of the counsel to the fullest. Even in cases where we were inclined not to grant,
Right.
we have allowed ourselves to be convinced that it is not made up. But in this particular case, what we are trying to find out is whether if it had been added on an earlier date, which is
Right.
there on the records of from wherever the certified copies have been brought, it is there on record, whether that part was placed before this court or not. If not, then this bill petition goes. That is for your assisting counsel to answer. What do you say?
My important was the victim got recovered on the same day.
Huh?
The victim got recovered on the same day.
Recovered on the same day. There is no rape. No rape. Then why do you say rape?
Lordship, will kindly go to the state.
Huh?
Lordship, will kindly go to our statement.
Okay.
180.
Recorded before the.
180 before the magistrate.
But sir, tell us about this. He has to answer this.
Original custody.
3 months prior to the case being filed, the section is added. We are not told.
Okay. Then, can I have the, my lord, page 10, my lord? Page 10, my lord. The FI, my lord.
Yes.
The format, my lord, lordship, whether at the top, my lord, it is not legible in my copy, my lord. Whether seen, my lord, that date may be.
That is the whole thing. The
Yes.
certified copy, that is why we are asking for the certificate.
My lord,
This certified copy, which is, I will give you our file.
my lord,
Because this is something we need to stop.
my lord.
This half information, first of all. Second of all, we are not alleging for a moment that someone is involved as of now. About not divulging everything.
16,925.
16.
16:9. Now this copy, if you will see why we apprehend, you will see that the certified copies have been attached to the bail petition.
Yes, my lord.
That signature part,
My lord.
that part is not there.
You see the two flags I have given.
So when that certified copy is taken, we do not know.
No, my lord. And lordship.
Is it not?
Yes, my lord.
The stamps are there.
Yes.
The
my lord.
stamps are cut out,
Yes,
but the
my lord.
signature date is not there. Your friend might have it. Your assisting counsel may have the original certified copies. Where is the bundle?
No, the original is this one, my lord.
No, it has to be at the end of the page. There has to be one seal, Sirostidar, Sessions Court. Is it not?
Where
Oh, it was.
That seal has to, that square seal has to be there. We did it.
that is the statement lordship recorded and there is the allegation.
No, actually, separate with that person.
Not to effect
No, the minister.
16,925.
And Mr. Sharma, they have only taken the birth certificate from the birth and death register.
They
We
will have to
just-
first cross the first hurdle lordship, because.
No. This is what we are
Yes.
intimating you. Mr. Dotto,
My lord.
to avoid any inconvenience, can we have it tomorrow or day after tomorrow?
Let it be day after tomorrow, my lord. I'll take the instruction. It is seen, my lord, the certified copy is of 9925.
Hmm.
9925.
16925, the CD contains that order.
My lord.
So there can be two options. One, it was a genuine bona fide mistake,
Now,
and
one
this needs to go.
I also thinking, my lord, one thing, my lord. If a section is added, my lord, if we take the apply for the certified copy, we'll get the original one. Whether that part in the FIR, whether they insert it or not, my lord, I have.
No. Now, Mr. Dotto, when you had started practice and when we had also joined in after you,
Right.
there was a practice of going through the entire trial court record or the remand court record to find out what is the case about.
Yes.
Bail petitions cannot be a matter of run-of-the-mill things.
Right.
We take a bail petition, aa gaya, maar diya.
Right.
It cannot be that. We are
Right.
talking of, we are being so sincere about people's liberty, right to liberty, this and that.
Right, my lord.
And petitions being filed half-baked. And because we think it's a bail petition, it is taking a routine course.
No, my lord, only one point, my lord.
This 19-9 order, 16-9 order was a part of the record.
Yes, my lord. Actually, what happened,
Of
my
the
lord,
magistrate court.
generally, my lord, what happens, my lord, we see, my lord, people apply for the certified copy of the FIR.
Huh.
If it is a anticipatory bail.
That is fine. The moment you have a wakalatnama, the entire record can be inspected. That has to be inculcated. Otherwise, this is perhaps the fifth or the sixth time. We have stopped proceedings only to find out
No, my lord,
how to proceed with it.
I'm not blaming anyone, my lord.
We are not,
My lord,
definitely not.
my lord,
It is a
the-
culture to be developed.
My lord, the accused person, he has applied for the certified copy of the FIR.
True.
And the FIR copy has been given. And he is not aware whether a section has been added or not.
No, true. It can be a very genuine. We actually hope it is a very genuine
Yes,
mistake.
sir.
But once we come to know that there is an added section,
My lord.
in our records, it has to be corrected.
Yes, that's true, my lord. Then in that case, my lord, I may be allowed to file an additional.
We'll
additional
allow you that.
affidavit,
We'll
my
allow
lord.
you that.
Right.
We'll allow you that.
Yeah.
But then this culture of going through the entire, because it is a professional matter we are
Yes,
handling.
my lord.
The engineer, he cannot stand up to say that I do not look into the quality of the sand or the.
That's true, my lord. Now
This cannot be. We cannot allow this trend to go. That we have a certified copy from somewhere, and we just file a petition and we try to get it done.
no, my lord, the general practice.
That is that when a file comes to you as an arguing counsel,
My lord.
we definitely appreciate. We'll go by whatever is on the record. You will not go into the behind story case, but the one who is
Yes, my lord.
assisting you, he has to know it on the fingertips. This is what. That is when we can try and give something to the society.
Well, generally, what happens, my lord?
Yesterday we saw a case diary
My lord.
where there is a particular statement. This man has been arrested in many other similar offences by many other police stations.
My lord.
Unfortunately, the IO does not write one PS case number.
Yes.
Had there been 2 or 3 PS case number in the CD itself, it would have been so easy for us to decide whether this man requires to roam freely in the society or not.
My lord. Well, it is the duty of the prosecution also.
Hmm.
Whenever I first apply for bail, my lord, in that case, my lord, in the forwarding report, they have to state that these are the number of cases you are pending against. My lord, that has been held in my lord, that far. I may be allowed to file an additional affidavit.
It has been pointed out by the learned APP that there is an added section that by order dated 16/9/2025 of the Judicial Minister First Class Morigao, 65 within bracket 1 BNS read with section 6 of the POCSO Act was added. Full stop. The learned counsel appearing for the petitioner has submitted that he would like to peruse, he would like to verify the same and file an additional affidavit if so required. Accordingly, list this matter again on when, sir?
My lord, can it be on Monday, my lord? Because I have to take the certified copy of that order, my lord.
It is your choice. The date is your choice. We don't have any
My
difficulty.
lord.
Monday?
Monday, my lord. Or
2nd of
if
March.
my learned friend provides the order date, my lord, then I will.
16/9/2025 is the order date.
16/9.
2025.
At the same time, he may take another instruction, Lordship, because in this bail application, he has not stated that he had earlier filed another bail application before the concert court, which was also rejected. Let him take that instruction.
That is not required, my lord. I have come to the higher court, my lord.
No, he earlier
Right,
filing of
if any bail application-
if any bail
No, my
application has
lord.
been
No,
preferred and not rejected or allowed, anything, Lordship,
Well,
they
that
have to
is-
state before the court.
No, no, my lord. There is no hard and fast rule, my lord. If any bail application is rejected in this court, my lord, in this high court, then I have to make a statement, my lord.
You are for the father, you are appealing for the father, is it not? You are appealing for the father of the alleged offender,
No, my lord. I am for the main accused, my lord. Babul Ali, my lord.
Babul Ali.
Babul Ali, my lord. Uh,
You learn that APP has submitted that an earlier bail petition had been rejected. The details will be provided to this court on the next date fixed. List again on the 2nd of March.
By the, or Lordship can also call for the order, Lordship, because the order is not uploaded. Because that will indicate, Lordship, because it was after adding of the section. So if the accused was aware of that section, it will make things clear, Lordship, because it was rejected on 25/9/25
Huh.
after adding of the section.
Should we call for the order? Can you get an order
I'll
produced?
take the order, my lord.
One copy of getting one order produced, because
It's from the additional session judge comes special judge Pokso.
Additional session judge.
the order dated 25/9/2025
Yes, passed in
passed in
bail application number 74/25.
25.
Order dated 25/9/25.
Well, I will have it, my lord.
Shall
Lordship,
also be
fixing-
produced before this court by the petitioner.
Huh?
By the petitioners.
In that case, well, can we have it on 6th, my lord?
6th of March.
6th of March. I'll
Sixth.
obtain the certificate.
6th of March. 6th of March.
26.
Yes, sir.
Is that it not everything?
Case diary is awaited.
Petitioner is on interim, Lordship, and
Ah.
CD has not been received.
The case diary is awaited. List again on 20 March 2026. Interim protection granted earlier continues.
Item 29.
Hmm.
29.
So see, here the service report is still awaited. There is an office note, Lordship.
Have taken steps, Lordship.
Huh?
Have taken steps, Lordship. And Lordship. And have been solicited.
An acceptance notice on behalf of the petitioner has been received.
That, Lordship, is regarding the copy furnished to us, Lordship, probably.
Eh? What do you call it? A refresher course is necessary, apparently.
I have been made as an absconder, sir.
Huh?
I have been made an absconder solicited accused, Lordship.
Oh, you are an absconder.
Absconder, Lordship. The allegations are, Lordship, under section 14 and 15, Lordship.
Your what is the accused name? Sabina Khatun.
Abina Khatun, accused number 2, Lordship. And my husband has been arrested long back, Lordship, accused number 1, Lordship. The main allegation is that, Lordship, I have invited that girl to our home and thereafter make photo and subsequently circulated, Lordship. My husband has been arrested and phone, everything has been seized.
You are assisting. The allegation is that you are assisting your husband to do all this.
And Lordship, charge sheet has been since filed, Lordship. So I am paying, Lordship, for Lordship, my grant protection, Lordship.
Why?
I will, Lordship, face the trial, Lordship, because I have 3 minors.
If the charge sheet has been submitted, then you should go and appear. Why should we entertain a AB?
Your Lordship can.
You did not participate in the trial.
My husband has been arrested, Lordship.
You did not participate.
No,
Did you?
this
Were
has-
you under protection during the trial?
No, Lordship.
No. Where were you during that time?
I'm in house, Lordship, and no notice was also served to me, Lordship.
Huh.
I have not been actually approached also, Lordship.
Huh.
Because
So when your husband was arrested and you had you knew that the FIR contains your name,
FIR contains
you did not deem it fit to approach any authority.
no, Lordship.
And then, although you were sitting in your house, the police did not arrest you.
Charge sheet has been filed.
Thereafter, when the charge sheet is filed, you do not go before the trial court. You come to the High Court to file an AB.
Because I have apprehension that when I go to trial
The
court, Lordship,
apprehension is genuine,
I
sir.
will be remanded, Lordship, and I have 3 minor side. Lordship.
Apprehension is
I'm a
genuine.
lady,
You,
Lordship.
you do not participate in the investigation. You do not participate anywhere. It is only where that now trapped. Then one AB for the wife. Then co-accused has been granted an anticipatory bail. Therefore, the main accused may be granted bail.
I am not seeking.
And then 1, 2, 3, 4 steps.
I
Walking
am
down.
not seeking that on ground, Lordship.
We are not inclined at this stage.
Lordship, I am a male.
One who has not participated anywhere, not approached any court.
I'm appearing. I am the person.
Why would she level an allegation against you?
Lordship, Lordship, can I see the FIR?
No, why did she level that allegation against you?
Lordship, another accused number 3.
Huh?
Another accused number 3 is
Huh.
also here, Lordship. And the Lordship, what happened, Lordship? The girl married to Lordship one my relative, where I objected, Lordship, because she was a minor and I have objected. That is why the main reason why I have been made as an accused, Lordship.
No, what happened again?
The lady has been married to my relative, Lordship, and I objected that, Lordship. That's why they had love relation, and I have objected their marriage since they are minor, Lordship.
Why don't you treat this as an FIR? Page 7, para 8. That minor is married to someone. Pick up her husband.
That is the actual fact, Lordship.
Huh? CD not received.
Scan copy, Lordship.
Scan copy is here. No. What has happened to this allegation? Rizabul Islam, this is on oath. Hmm? Sir. Very clever way of using the POCSO Act if this is true.
The FIR has been lost by the Lordship. FIR has been lost by the victim girl herself.
Huh?
FIR has been lost by the victim girl herself, Lordship,
Ah,
not by her guardian,
I
Lordship.
understand. Yes, this requires a deeper look, sir.
Lordship. I will go to the scan copy once, Lordship. In the meantime, let service be completed, Lordship.
The victim girl's statement is recorded. She was sent for medical examination. She has denied. Hmm? Let's have should we direct that investigation on the basis of, should we require a report on the allegations made in paragraph 8 of the.
Regarding her being married.
Ah, yes. Then this will be a total misuse. If she is actually married and has a husband called so-and-so, her statement that she is a minor, then this para 8 becomes true. Is it not? To that extent.
Yes.
Not the allegations against them. And then, before proceeding against her, whether a false case has been lodged has to be first gone into by the POCSO court, special court. The informant has to be taken into,
Yes.
there'll be big trouble. If this is true, have a report called for.
Whether any birth certificate or anything has been given in support of her age.
Huh?
In support of her age, Lordship, whether any document is.
If the birth certificate, if the POCSO is continuing,
Yes.
then the presumption is minor.
Yes.
Then the husband is married to a minor.
Yes.
Then her objecting to the same. If it is true,
Yes.
she is trying to take the intentions of POCSO ahead,
Yes. I am.
trying to stop that act, and she is being made a victim.
Yes.
Will we not interfere? We are required to interfere then. Certificate, yes, some certificate was there.
Tarsi stated birth certificate has been seized also.
Huh. Seized one original birth certificate.
I may be granted.
Ah, all are found to be correct except mismatch of victim's surname. Everything is pointing towards what he's saying.
Lordship, and one more thing, she is the wife of one Rizabul Islam.
Ah,
Whether his statement is there, Lordship, I may be allowed to.
he is saying, yes.
Yes.
We'll have it at 2, find out. We'll take this a little deeper. This is an act which is putting a lot of people in trouble. Maybe rightly so. They should be put in trouble if they are violating, but if it is being misused, the provisions are there in the act itself. And you can also have a talk with the IO, whether some preliminary report can be found out regarding that allegation at paragraph 8. If it is to some extent true, we may consider the AB. If it is a case of simple harassment.
May I pray it may be taken up tomorrow also?
Tomorrow morning, tomorrow, let him go through the records and also have some instruction from his, at the request of the learned PP, list the matter tomorrow. Mr. Bodhakur, give us 2 minutes. We need to put something here.
I understand it. Wanted to peruse the MOU. What we will see, internet page number 10. It's down below. Here, point number 1. Kasar Sugar Mill, Assam Spun Mills Limited.
No. Page numbers are not missing. Yes,
10,
page
10,
10, yes.
Serial number 5, in para 1. Assam State Minor Irrigation Development Corporation Limited. Thus above that, as identified by the government of Assam, following PSU shall be closed by 31/12/2003. So this was thereafter in the next page. Also, we will see a policy paper on voluntary retirement scheme shall be formulated because some has gone on voluntary retirement. They opted for absorption. So this was the MOU that was mentioned in the notification dated 13th of May 2005. Page 28 of the writ petition. Now here, point 4 and 5.
3, 4, and 5, Lordship will see.
Hmm.
They are entitled to pensionary benefits as admissible under the Assam Service Pension Rules 1969 on their absorption
Hmm.
/ appointment in irrigation department. Court says they will have to sign a undertaking individually regarding non-claim of seniority in irrigation department for their post services rendered under the corporation before joining in irrigation department.
Hmm.
No equalization of pay shall be entered.
Now you are denying them the past services in the corporation, saying that only your period in the irrigation department will be taken into account, not the past services in the corporation.
In fact, my lord, the very policy of this, my lord, SCPS, it says, my lord, that if a regular government employee, there's the term used, Lordship will see page 42. Introduction, my lord. This is the, my lord, SCPS. It was introduced in 2011, 25th of May 2011. See, Lordship will see introduction number 1. The scheme would be known as Assured Career Progression Scheme for the state government employees. This is very important. And shall involve 2 financial upgradations under the SC scheme for employees of the government of Assam. So they became, my lord, employees after this, my lord, notification of 2005. Now thereafter they rendered, my lord, regular service under the government of Assam. Now during their tenure, my lord, if for say 10 years, they have to render their service without any promotion, they will get 1 increment. And in the next, my lord, 14 years, which goes to, my lord, 24 years, again another increment is given, my lord, because if between this period, my lord, there is no promotion. That's what the scheme says. And that 24 years service will have to be under the government of Assam, not under a PSU. Because, my lord, the para 2 says the benefit under the scheme would be given twice in the entire service period. First, one from completion of 10 years and second one after completion of 24 years of service if they do not get any regular promotion within first 10 years of regular service. Lordship will see the word, my lord, regular service, and 2 regular promotions within 24 years of regular service. This is the scheme, my lord. They cannot claim that, my lord, their past service should be counted for calculating this particular part. Now, my lord, from 2005 to 2015, before, my lord, the 2017, my lord, modified Assured Career Progression Scheme came into force. They must, otherwise, they will be entitled for, my lord, 1 increment if they were not promoted during this regular service from 5 to 15.
When were they absorbed?
That notification is of 2005.
2005. So your first ACP would come in 2015.
15.
Per
Maybe
the
16 or something, yes. Or 16, my lord. Whatever is there, my lord, date of absorption. in
so
service,
15 for those in 15, it will come first time in 2015, and the second one will come after 14 years. It is
In that 17 came in where there was, my lord, 3 increments have been
10,
provided.
20, and 30.
Yes.
So on completion of
Automatically,
20 years.
They will get, my lord, instead of 24, they will be entitled in 20 years, then 30 years.
So now it will become 15 and 25. And they are saying that if it is if the period in the corporation is taken into account, then we get it even now also. 10, 20, 30.
That cannot be, my lord. This is not the scheme, in fact, my lord.
Yes, sir. What do you say about this page 45?
One more thing, my lord.
He has one more.
Let him page 55. Again, my lord, the 2017 part. Introduction 1 is same, my lord. It is the, my lord, modified Assured Career Progression Scheme with the following provisions. Introduction A, my lord, para 1 says, my lord, same thing, my lord, regular state government employee. Now, lordship will see salient features of the scheme. B, 1 says MSCPS would include grant of financial upgradation 3 times in the entire service period, namely on completion of 10 years, 20 years, 30 years. So those employees who do not get 1 regular promotion within the first 10 years, 2 regular promotion or ACPS benefit within 20 years, or 3 promotions ACPS benefit within 30 years of their regular service. Here, my lord, one more, my lord, point in the Roman 10, which is under challenge before the Honorable Court. This particular clause is under challenge. It says the past service rendered in public sector undertaking under any other state public sector undertaking, autonomous bodies, state level public enterprises, or any other statutory body shall not be counted for the purpose of MSCPS. This has been clarified because, my lord, it says regular service, very scheme says, my lord, under the state government. Now, my lord, they have challenged one more letter, my lord. I don't know why it is under challenge, because page 51. Lordship will see page 51. This is the first prayer, my lord. They are challenging this letter. This is a letter from the Under Secretary Government of Assam, page 51. 51. From the Under Secretary Irrigation Department to the Accountant General, and pursuant to one letter of the Accountant General, this has been clarified. Also, will see in inviting a reference to the letter and subject cited above, I am directed to inform you that as per Finance Bureau Department notification dated so and so 6/7/17, that is the new scheme. The past service rendered in public sector undertaking under any other state public sector undertaking, autonomous bodies, state level enterprises, or any other statutory body shall not be counted for the purpose of MSCPS. In this connection, a copy of the notification so and so. The service book in original of Sri Dilip Kumar Kalita so and so is returned herewith for needful. Well, this particular letter is in connection to a proposal given by the Irrigation Department to the Accountant General pertaining to Dilip Kumar Kalita. That has been clarified. Now they are challenging this, but Dilip Kumar Kalita is not a petitioner in this particular batch, in this particular petition. I've checked that my lord petitioner's names.
No, the reason given in this letter will be applicable to all.
To all, yes.
Therefore, since that will be taken into account while deciding their pensionary benefits also, so they are challenging that content.
Pension they will get. That part
No,
will be counted
the
for-
quantum of pension.
Yes.
If they get the MSCP's quantum changes.
It
So because this letter will make a hindrance for them also.
yes,
Dilip Kalita does not want to challenge that.
The mind
is
of the
another
authorities
thing.
are clear, my lord. They will not be entitled.
Huh?
The mind of the authorities are clear, my lord. They will not be entitled.
None will
Perhaps,
be entitled, and therefore they are
But
putting a challenge to that also.
But
With
the
or
very-
without Dilip Kalita, we are not
Very
concerned.
scheme says, my lord, it will have to be regular service. The
Yes,
scheme
sir.
is not under challenge, my lord. It is-
How do you say it is regular
Lordship,
service?
so far as my contention is this, Your Lordship, Your Lordship. First of all, Your Lordship, this is not our prayer that we should be paid, Your Lordship. Already paid, Your Lordship. What they are saying that they now want to rectify it. Your Lordship will kindly see that they have already paid us SCPs and MSCPs, Your Lordship. Both in respect of one MSCP.
Taking your past service into
In account, Your Lordship. That's what my submission is.
recovery, we are not
Because
allowing.
they have already taken that into account, and thereafter, Your Lordship, they have paid us, paid every one of those persons who have been. It is not that, Your Lordship, out of the around 200 employees absorbed in the irrigation department, only few of them have been paid. All of them have been paid, and most of them have already got retired, got the benefit, pensionary benefit based on the benefit given to them under SCPs and MSCPs. Only this has come up only in respect of these persons, Your Lordship, that too after retirement of their retirement, number one. Number two, Your Lordship will kindly see that they have applied their mind, and in fact, they have decided to count it. That is why they have paid it, Your Lordship. And had it not been the case, Your Lordship, they would have immediately decided to rectify that granting of the benefits under ACPS and MSCPs, Your Lordship. That they have not done, Your Lordship. And thirdly, Your Lordship will find that if Your Lordship go through this, that is why we have put that to challenge, Your Lordship, that particular provision. Your Lordship will kindly come to page 28, that the order notification, Your Lordship, based on which our services are absorbed. Your Lordship will find that there is specific mention what we cannot get, Your Lordship. We cannot get, Your Lordship. Your Lordship will kindly
You will not get the seniority
seniority
and equalization of.
claiming it. We will not get the seniority. It's specific. Had it been the intention of the government at the relevant point of time, they would have make it abundantly clear that our past services will not be counted for any purpose, Your Lordship, other than past pensionary benefit. That is not there, Your Lordship. That is why, Your Lordship,
the decision of the government to pay us ACPS and MACPs will have to be considered in that particular context, Your Lordship, in my humble submission, Your Lordship. Because, Your Lordship, it is very specific that I will not get the seniority. Yes, we are not claiming seniority over the other. I have not claimed for equalization of the pay, Your Lordship. That's specific. Had that been the intention, it would have also been mentioned that you will also not get the benefit of past services for other benefits also. That is not there, Your Lordship. And that is why, Your Lordship, the grant of ACPS and MACPs is a conscious decision on the part of the authorities to give us the benefit, Your Lordship. And in fact, Your Lordship will kindly see that the letter of the, Your Lordship may kindly page 52, Your Lordship. What AG says, Your Lordship. Accountant General says, Your Lordship. Page 53, Your Lordship, third paragraph. Now, at the end of the day, Your Lordship, these are beneficial provisions.
No, but see,
These
to
will-
our understanding, what we have understood till now, will be very clear on this. What we have understood till now is that perhaps there is force in his argument that you could not have been considered as regular employees, and you would not be entitled to have your period under that corporation to be counted for the purposes of your what do you say, the purposes of your MACP and ACPs or the other benefits that you have drawn. But now that much water has flown,
Lordship.
now that the AG, this is now again saying this, you had already refunded the government share of the CPF for the pension part and everything. You have done so much of work has already gone ahead. To how far it would be reasonable and justified to now bring down your pensionary benefits because of a mistake which had occurred in the year 2005 to thereafter in 2015.
Lordship.
Thereafter, it continued up to 2018-19. Supreme Court says that there is no bar in the government doing it. But then there is also other law which says that after much water has flown, even if a person was senior to someone, a belated claim will not work. He will not be allowed the seniority because it will disrupt everything that a man had planned, a junior had planned in his life. In the present case, we see taking out this benefit will disrupt all your pensionary plans.
And Your Lordship will kindly see the how we got discriminated. Had they not paid us at the relevant point of time, we could have challenged that decision at that point of time also. Your
Not
Lordship.
only that, you say that others have been allowed to enjoy
Yes,
that benefit.
enjoy the benefit. And that is
All
what,
these factors together, Mr.
and
Gogoi,
that's what CCC,
even if what you want to do now is correct, let us say, correct in law, putting everybody to a disadvantage at this point of time, when they are no longer in service. You have retired.
No, we have retired.
All have retired. At this point of time, it is not about the correct fixation of pay within one increment or two advance increments or something like that, where the scale remains the same. It was only the quantification of a little amount. Here, upgradation to the next scale is being touched, thereby disrupting the entire pensionary benefits of these people. After 10-15 years of having granted them that belief, would it be...
It will come regarding recovery part.
No, not only the recovery part. See,
After why not?
they were drawing a scale of something, say, let us say 200 to 500. The moment you allowed them the first ACP, they would go from 210 to 550. You granted them the second.
Right.
They had gone from 250 to 300, that scale. The entire scale moved. Now, the moment you want to correct all of this, they will come down to what? 200 to 500 again back. Is it not? The entire scale comes down. It is not a question of an
This increment is added to the basic.
it is not an increment, that is what we are saying. It is not an increment, annual increment sort of a thing. The scale changes.
Yes,
Of course,
scale
the
changes.
slab will
When
come in now.
when the slab changes, the retirement
The
benefit
fitment
will
level
definitely
will be-
come down by a drastic
Yes.
amount.
Revision and will be another fitment.
Everything will come down, and it will not be a minor correction on the part of the.
But my lord, will they be entitled for any undue?
You have that entitlement, but given the 30,
But will
20
that
years or
mean-
15 years already gone.
The knowledge. Will have to be in the proper manner.
Even in disciplinary proceedings, the court at times takes into account the excessive delay being caused.
No, my lord, Lordship will see, my lord, that Rafiq must is this case. There, my lord.
Recovery is gone. Recovery, we are not even giving a
This
second thought.
court in various cases has given that, my lord, that pension will have to be in the correct situation.
True.
Ultimately, it's public money. It's not that. my lord-
True. That is that there are also cases which says that if the incumbent is put to a disadvantage which is not called for at this stage, are our hands tied on that? The ultimate aim 226 is to do substantial justice.
Been finalized or not, my lord? That
No,
part-
not yet.
So they are not getting the pension as of yet.
No, not.
They are getting a
my lord,
provisional pension.
provisional
Provisional.
pension,
they are getting.
Pension we are getting.
That's why I'm saying, my lord. Had it been a case that, my lord, they were enjoying the pension, monthly pension, my lord, thereafter we just come to our knowledge. And we have-
A man plans his retirement
That is what your lord.
on a scale. A man plans his retirement on a scale. The moment you change the scale by 2 stages, there must be some who had got 2 MACPs.
No, my lord, Lordship will have to see this part, my lord, that
Listen.
from the date of their, my lord, absorption till their date of.
We understand the correctness of the law which you are trying to implement. We have started with that.
No, because I'm saying, my lord, so far as the first petitioner who has signed the affidavit is concerned, my lord, it is 62 in 2023. So, my lord, 60 years, if we say, my lord, he will be in 2020. From 2005 to, my lord, 2020.
Now kindly see
15 years.
the day when you retired, these issues were not taken up. The day when he had retired. So till the day of his retirement, he was under the good belief
My lord,
that nothing changes in my pension.
My lord, what is the stand of the irrigation department, my lord? I'm not aware. We will explain this because ultimately they are the authority will release it. Because
When-
the
when-
scheme says, my lord, there will be a committee of every department who will look into this aspect.
Interference in their pensionary benefits after they retire with a belief that this is my scale.
And
We have to see the
my lord,
when we
kindly
look into
consider
the
one aspect that, my lord, how many persons are there in
Huh?
this category? If that can be placed, my lord, say, my lord, hardly few are there. Today, my lord, before this honorable court, my lord, some 7% is there.
see, in every case we will be restricting to the prayers made by the petitioners, and in cases like this we would even bring in fence sitters and everything to see that no other person gets a benefit because others have got it. That is a separate thing that we will look into.
Oh, my lord, there may be persons who are still, my lord, in service, who have been absorbed. Considering
They know what is going to happen. They know what is going to happen. The department will take care that before their retirement comes, they make the necessary corrections. They will not wait for if the department deems it fit to sleep. We cannot help. Once this is an issue before this court, they know this is the trouble coming up, and if everybody waits
my lord.
to put it on the shoulders of the court, we would throw away that weight, but we would not be very happy.
So in that regard, my lord, let me have the instruction on this point. That how many persons are there, my lord, in this category?
We have 7 persons before us who have retired, without being put to knowledge or put to notice that your entire thing may now change.
Right.
Also keeping in mind the fact that this is not a minor change in their retirement benefits. It is not a matter of an increment or 2. It is a matter of where their scales would change, drastically affecting their retirement benefits.
But
Those who had 2 of them
my lord,
would have gone up 2 scales.
On the date when your lordship, this letter was written by the accountant general office.
Lordship will see page 11, madam.
It is this provisional pension part is only a way out if there is some difficulty in the regular pension.
Yes.
Otherwise, they are entitled to
In
regular
preparing the
pension from day one.
No, but in preparing the pension papers and all.
Oh, your
that
pension
will-
rule says that it has to be done, it has to be started 3-4 months prior to that, and on first month of his retirement, he is entitled to a regular pension. Some problem is there, start with the provisional pension. Is it not? So provisional pension, that they were drawing
Area
provisional
amount they
pension is
get,
out.
ma'am. Area amount what is to be paid as a regular pensioner, that also they get after their pension is made regular.
That is a trend that the government has started. The provision, the pension rules does not allow that. Pension rules has said that you give the pension from day one.
So for that, they will have to prepare their pension papers. If the employee will have to take the initiative.
Whatever it is. So therefore, we are not going to that aspect of the matter, but
Page
provisional
11
pension is not the answer.
Chart, my lord. The numbers of my lord increment they got, my lord. after
When?
the scheme.
Where
Page
is it?
11.
Page, paras.
11. It's there.
Page
There-
11.
There's a chart. ma'am.
Page 11, yes.
So petitioner 1, he got 1. That to ACPS. Petitioner number 2, he got 2. 3 got 1. 4 probably nothing has been mentioned.
Yes.
5, 1, 6, 2, 7, 1.
Hmm.
And Lordship will see in the next page, their date of retirements are 2001 petitioner number retired in 2001, petitioner number
No,
2,
2021.
21, sorry, 21.
21 and
22,
22.
Yes, and 23 even. That is
21,
what it is. Petitioner number 7 is he retired in 2023.
No, for those persons who have retired without having an idea that this is going to happen to me, changing down of 2 steps would be disastrous. When others like him who retired without that knowledge are still being afforded it.
And in fact, your lordship,
Negative equality is also playing in our mind. We'll have to answer the question of negative equality in case we go in favor of, let us say, petitioner number 1, petitioner number 2, petitioner number 3, then petitioner number 4, 5,
So all
no, sorry, 4 and 6. 4 and 6, 4, 5 and 6.
four has not got your lordship, but he's-
No. Whether he gets it or not is a second thing.
different.
The difficulty
has
that may be
retired
faced by him.
No, my lord, if he has not got my lord, then increment is not there. So
That
issue-
will be a subclass in a class.
Yes.
That will be a subclass in a class, but otherwise his date of retirement is
2022,
20.
31, 12.
pre the letter dated 26/8/2022 at page 50. That is the letter which has started the entire fiasco, na? Page 50 is what has started the fiasco. So that is issued on 26/8/2022.
2020.
Is it not?
Yes, ma'am.
Huh?
Already, this has been detected by the accountant general. mostly.
This letter started the fiasco. So anyone who retired prior to this would not have the knowledge that my pension will be at stake. Is it not?
My lord, ma'am.
So anyone who got something before that, will he be required to be allowed to retain it? Otherwise, yes, regular service, it was not those things
Very
we
clear.
will answer.
It is very clear.
We will answer all those things.
Hmm.
But will we not have to look into the justice part of it?
Of the court of equity, your lordship.
The equity,
The
my lord,
justice part comes into our mind.
no, one, that's why I'm submitting, my lord. They are getting the provisional pension. As on that, my lord, it's not that, my lord, they are getting regular pension. In between, my lord, we have decided that we'll go for
No.
recovery and my lord,
Provisional
refixation
pension
of
was
this.
provisional pension was not because of this issue. Kindly see, the provisional pension that was paid to them was not because of this issue.
Maybe for this issue, my lord. For this issue,
is
because my lord,
after
in
the
between
provision-
there is deliberation of the accountant general with the my lord, department that regarding this, my lord, increments that have been given to them.
That has to come from the irrigation department.
Yes, well, that's
That
what
is the why. Yes, why the provisional pension? Why provisional pension was paid? Why was the regular pension not finalized?
They have filed an affidavit.
Only because the proposals were sent, therefore provisional or what?
This, sir. One is by accountant general and another is by the departmental notes. Page 58 also. Page 58 of
Lordship will see my lord para 98, my lord para 4.
Page 98.
Page 98, serial, my lord, page 98. Lordship
With
will see-
regards to content of paragraph 10. That is what you are reading.
Yes, my lord.
Huh.
Lordship will see, my lord, down below, it's regard, my lord, petitioner number 1. So and so. Similarly, the case of the petitioner number 1, Sri so and so, past service rendered under AMIDC, also taken into account while granting ACPS benefit. As such, while later dated so and so, the office of the deponent had, while returning the service book of the petitioner number 1, requested to clarify whether past service will be counted for ACPS benefit or not, so that the office can take necessary action in the matter.
This man retired in 36/20/21.
Yes, he
Is it not? Then 1 year later, this issue is 1 year and 3 months later, this issue is raised. Had he kept serving, he would not face this situation. Is it not? He would have kept earning silently. Even people as of today are earning silently. Agricultural department has not stopped the others who are yet serving. They are getting the benefit. Why kill a man who has already gone on retirement and now he will be made to face a peril? When others who retired before him are not facing it, persons who are serving are not facing it. Would it be justice to draw it out of his mouth? Something which is...
But they have not specified who are those persons. They will have to point out that these are the persons who
we'll have to make a general observation.
Us, and they are entering.
That is part of the record, Your Lordship. It is there in the letter of the Accountant General.
What?
Your Lordship will kindly see the Accountant General's letter at page 53, Your Lordship. Page 54, it says, further, the pension cases of around 50-60 non-gazetted employees, cases out of 262 numbers of employees have already been finalized from this office for the last couple of years. In the cases on the basis of MSCB benefits are taken into account as per certification, recording of benefits done by DDO, HOD or GOP in the service books from time to time, and at this stage, the question of recovery. That's a different, but the point is that already
those people are already drawing it. Their pension is not being changed.
Let me have that instruction in that case. At least, my lord, probably, my lord,
Even if you attempt to change it now,
if it has been changed, my lord, in that case, my lord, they will, if they cannot get that benefit.
but then every time a question comes up, if we keep, then it is no longer part hard.
Your Lordship will always confine it to 7 persons.
No, it will not go beyond this.
Lordship, that is what your
It will not go beyond this, and we will give our reasons
Yes,
why not.
Your-
And even all the 7 in this are not coming in. For example, the person who did not get anything,
Lordship, he will not come.
he will not come in. Petition number 4.
Petitioner number 4. He is not.
Petition number 4 is out.
Okay.
Now, if we come to petitioner number
Rest have
7, petition number 7.
he got one.
It is during his service period that this entire fiasco started. Is it not?
7 year Padgiri. Padgiri. Your Lordship.
It is during his time the fiasco started. So, in case his MSCPs had been removed at the time of during his service, then this is not the cause of action. Then he has to go out. Again, if you see number 4, I think we have already removed. Number 4,
Number 4 has.
he has to go.
Number 4 will not get, Your Lord.
So 1, 2, 3, 5, and 6.
Lordship.
1, 2, 3, 5, and 6. These are the persons who retired with the belief that nothing is wrong with their pension.
Padgiri retired in
With
2023.
the additional fact that people before them have got it, and with the fact that people who served after them continued to get it. Would it be fair on your part now to change their entire retirement life? although you are correct in your submission in law, and we have noticed that Mr. Bhattacharya has not attempted to say that they were in regular service. We have noticed that also.
No, you're not. That is why you're not.
This is just off the record.
No, why I am saying this, Your Lordship, that's why we have put that particular clause to challenge, Your Lordship. That particular clause.
No, that part, my lord. If
We
that
will
is
not,
part of, then, my lord, everybody will get the benefit. It's not the case here in my lord. They say that we have retired, now it should not be done.
No, and that is the only thing that is touching this court.
Yes, Lord.
And my lord, their submission that my lord.
Had they been in service,
Yes.
we would not have interfered in any manner. Here is a case where they retired with the belief that this was correctly done by the department.
But-
Correct fixation is allowed. Correct fixation is allowed in a number of cases by the Supreme Court.
Yes, sir.
We have no doubt on that.
Yes.
But if that correction has the effect of a cascading effect of a man who has already served and retired,
That will be in every case, my lord.
not in every,
In every
case.
case.
That is what we are
No.
saying. This case is peculiarities. It is not the case of a recovery of an increment, of an allowance, of something which does not finally alter everything in the retirement. This is a case where his entire retirement changes. Two scales. It is as if two promotions. No, it's not an increment. Please let us again read it. Come to ACP.
Yes, sir.
Come to the ACP scheme. What does the person get? Tell us. Does he get one increment? That he gets an yearly increment. Huh?
Under the so-and-so scheme, the employer so-and-so, the benefit.
What is that upgradation we are asking you?
Shall be given twice in the entire service. First one after completion of so-and-so, so-and-so. The ACP scheme is designed only to provide financial upgradation. It is neither a regular promotion nor required creation of new post.
Higher grade payment. Do you see at page 43? If the pay goes to a higher grade, if we have understood the ACP scheme of the central government, which subject to correction, between the posts of constable and head constable, if there are 3 more grades present, which is not there in the regular service, but 3 grades are given in the financial rules, that whatever pay rules. 3 more grades are there. This man goes from A to D when he gets a promotion. When he gets the ACP benefit, he does not get D, he gets B. He does not get the grade, the pay of the higher post. He gets the immediate higher grade given in the pay scale of that particular thing. So therefore, it is never taken as a promotion because he never goes to the grade pay of the next post.
Promotion, yes.
He does not go even to the pay scale of the next grade, next post. He only gets 1 grade more than what he was drawing. So that 1 grade more affects the promotion drastically. Affects the pension drastically. In some cases, it is twice. Will it not come down by 2 grades?
It is the basic pay that is not.
Basic pay is at the end of the day, you will see at the end of at page 46, you will see.
Only the grade pay shall be-
When he will get a regular promotion, he'll get 3% more than what he was drawing. Get it?
My lord.
He will just get 3% more because he took a promotion.
That's why my lordship will say it says first increment. So that upgradation is.
That increased pay is called an increment, but it is not an increment like the yearly increment. It
That
is an
is
increment in the grade.
Basic pay.
Increment in the grade. Once a man takes an ACP benefit and the next year he's promoted. Now what happens? Does he go 2-3 grades higher? No. He gets a 3% more in his grade pay is what the page 46 says. If you have taken an ACP benefit, then you get a promotion immediately thereafter. What happens? What happens to your pay? You get 3% more than what you are drawing in the ACP skill. That is all. So it is almost like bringing down his pay by 2 grades. On retirement, a person who retires, Can you bring it down by 2 grades? 10 years, 20 years after he has enjoyed that skill, can you bring him down?
But
Either you do your research or we do our research. And Mr. Botokar will also do his research. You have to show us that this kind of interference by the respondents now would not be called for in this length of time. Because otherwise we are convinced that it was not regular. Your challenge at this point of time is belated because your understanding was otherwise. That cannot be a chance to not have challenged it. The only thing that is playing in the mind of this court is those who have already retired with the mindset that nothing is wrong. 1 year after their retirement, they are given a jolt from the blue that maybe people before you have got it, maybe people after you are enjoying it, you are my target. Can that be done? But we will not keep it for long. We will keep it on the 27th. Either it is done on the 27th or we release it. Huh?
On 27th.
Release the matter again on the 27th of February, allowing the petitioner, allowing the counsels representing the protesting parties to apprise this court of the relevant judgments in the matter. We are not putting down what is the judgment, but we just like to know whether otherwise there is no case. Unless you can show us that their interference at this time is bad. Yes.
Seeking some more time, madam.
In
45.
yes. Seeking some more time for what? Affidavit.
Yes, madam. I asked to file a detailed affidavit.
He has spent the whole month waiting for the affidavit.
That I
Some
understand.
compensation we are thinking of unless he waives it.
Of the record, madam, they are finding it difficult to
Answer it.
answer the
Query.
formal question. Yes, yes, madam.
What did you say?
Those are very vital.
So
Questions
that's
that
why they
have
are
been
taking some
framed
more
by
time,
your
madam.
law.
No, this is. We are on item 40.
43 to 45.
By this week, I will get the instruction, madam.
Huh?
By this week, I will get the instruction. Next week, I will file it.
What was the query? I forget.
There are 3 queries, madam. Regarding publication of separate merit list and additional merit list.
But if it is not here by the 5th of March,
Definitely, I'll ensure, madam.
we
By
would.
this week, I will get the instruction.
No, if it is not on record on the 5th of March, then we would not be very happy about it.
I will ensure.
Yes, your cup of coffee goes back to 5th of March.
I'll ensure, madam.
At the request of Mr. N.J. Khatonial and Council appearing for the Education Department of School Education, release this matter again on the 5th of March, by which time it shall be ensured that the. No, we'll keep it on the 6th of March. On the 6th of March, by which time the respondent shall ensure that the affidavit or that the queries of the court are answered by way of an affidavit as required by the earlier order. Okay.
Deeply obliged.
The last occasion, my lord had asked me to take instructions whether the vehicle was removed from the blacklisting. It has been removed, my lord. It was
Removed.
on the
Now she can get the transfer done.
My lord.
That was your prayer?
Yes, Your Lordship.
Granted. So now on the basis of this, we can say that her prayer has been granted,
My lord, it has been-
the difficulties have been removed, and this WB criminal does not require any further adjudication. Heard the learned counsel for the petitioner, also heard
RB Goswami.
Mr. R.B. Goswami on behalf of Miss M.B. Bora, learned standing counsel for the transport department. Today, the instruction dated 4th of February 2026 has been placed before this court to the effect that the flag of not to be transacted with regard to the vehicle bearing registration number AS01GC 8514 has been removed in the system Bahan software. On 38/2025 itself. In that view of the matter, the learned counsel for the petitioner has submitted that if such tag has been removed, the grievance raised in this petition has been may be taken to have been redressed. Accordingly, this petition is closed since the grievance of the petitioner has been redressed by the respondent authorities themselves.
The instructions may be kept as part.
The instruction is kept on record.
But in this matter, certain queries were.
Just 1 minute, just a minute. Mr. Goswami, have you seen this notification? Clause 1 requires every past detail to be given, whether this or some other court. Have a talk with the filing section. Yes, the resignation withdrawal.
Certain queries were put to my learned friend for the bank.
I think he had submitted that it has to be accepted within a certain period of time.
That is correct. In fact, that
My
is-
instruction is that lordship, that so far withdrawal of resignation is concerned, there was no formal letter to that effect that he has withdrawn the resignation.
Okay, now let us go through it.
Good.
Where is your letter of resignation?
My lord, that is in the form of an email, my lords,
At page
at page 78, my lords.
72.
78, annexure 72, 18,
Page
78.
Punch my resignation in HRMS Bank of Maharashtra.
Yes.
And then
Is that correct?
completely bedridden. This is on 3rd of June 2025.
No, this is on, this is a forwarded email, my lord. This is on 10th of
10th of
February,
February.
10th of February at 5:47 PM. Because if your lordship.
547.
Yeah, this is.
Then what is the next one?
Then, my lords, thereafter, he, my lords, wrote another, he addressed another email. which is
79.
there. No, that is a different one, my lord. They have annexed it, the bank has annexed it. It is in the bank's affidavit in opposition, my lord. That is at page 152. 152, 153, my lord. This is, he says again that I am unable to punch my resignation in HRMS with error showing so and so. I pray to you that my resignation may be accepted on.
This is on 21st February.
21st February 2025. This
Huh.
is 11 days after. Now, my lords, why he is showing this HRMS thing? Because the resignation, my lords, has to be submitted through the HRMS portal.
So even if this letter, if is it your argument that even if we take this letter of February 10, 2025, since you're not able to punch it in,
Lordship.
There was no resignation submitted.
There was no decision.
Ah.
I say this because of a circular of the bank itself, my lord. If I may just hand
Okay.
over the circular, I'll give one copy to my learned friend also. This will be. Because all the resignations, my lord, are supposed to be, whether it is a VRS or whether it is a resignation, my lord, both have to be submitted through the HRMS. This is the circular, my lords, of 14th of September 2023. In fact, my lord, the bank has introduced this portal HR@1 click.
We have seen that, huh?
Lordship. So, and they have said that all the VRS resignations are to be done like that.
Hmm.
Now, if your lordship will come to page 3 of this circular, lordship will see that, you know, the portal has a certain process, my lord, in order to make the process, my lord, transparent, and also, my lord, to bring everything on record. Now, my lord, the bank has indicated at page 3 that this is the as-is process, means the existing process. Lordship, have that page. This is the existing process. Current process as followed in branches, zones, and head office is as follows. VRS resignation application is presented to the reporting authority through a filled hard copy format, etc., etc. This is the present existing format. Now the 2B process, next parameter. In order to improve the request flow and TAT with preserving of records at a central repository, the process of VRS and resignation is implemented in HRMS with below workflow and validations. Now, Lordship will see is stage by stage, application,
Yes.
further navigation, application type, total service duration, inactive service, active, bond period, date of resignation, disciplinary action status, reason for the VRS resignation, tentative date of relieving, request for early relieving, question. All this, this is the process. Finally, my lord, it ends. If your lordship will further come to page 6, my lord. This is the entire, this is now the on the part of the authority, what the authority has to do. A, applicant's disciplinary action status. B, disciplinary action details. C, recommended for early relieving, and so, my lord. Vigilance comments, legal comments, and all these loans, advances, etc., etc. Then further, my lords, page 7. This is the approval. Final approver is the approving authority who, on various recommendations from various authorities, processes the request, so and so. So this is, my lord, the process which had to be done. Now, my lords, to recollect, my lord, the petitioner had, my lords, traveled from Dehradun to Silchar, my lords, his hometown. And if your lordship, just before the page 78, for a minute, your lordship sees page 77. There were a series of communications, page 76, 77. There are a number of communications which are not denied. That my mother is ill, kindly grant me leave for a few days. I want to go to my hometown. So that was denied, that there is an administrative exigency, this and that. That was denied, and finally, this is the result, page 78. Now, my lords, page 79, lordships have seen, perhaps. This is the email on 8th May 2025. Now, lords, between this 10-2 and 21-2 and 8th May, nothing transpires. I do not receive anything from the bank. Bank doesn't say anything. Bank is silent at its end. So this is how things are. So now again on 8th May at 6:13 p.m., I say that I am writing to respectfully request for my transfer from my current position at Dehradun zone to Gauhati zone. Due to unforeseen and urgent medical circumstances concerning my mother, I am compelled to seek your understanding, so and so. Then he describes his mother illnesses, he says that I am exempt from the routine exercise of transfer issued by the Ministry of Personnel, so and so. He says, I have attached the relevant medical documentation from our healthcare providers to substantiate my request. I assure you that my commitment to my role remains steadfast, and this transfer will enable me to maintain my professional obligations without compromising the well-being of my mother. I kindly request your prompt attention to this matter and would greatly appreciate your assistance in considering my transfer to Gauhati zone. Your understanding and support during this challenging time would be immensely valuable to both through my family and me. So this is what I write on the 8th of May. And, my lords, in reply to this, they, my lords, at page 86 is their response on the same day. So this is their first response after 10/2/2025. And here they say that the competent authority has allowed the concerned employee to resign, and she will be relieved on 9/5/2025 after office hours and subject to depositing and repaying of all dues and loans. She will be allowed to be relieved on.
This is not done in the HRMS or whatever.
No. HRMS process was never done.
And that is why on 10.2 also and 21.2 also, I have said that it is enabled so that I can go to the local branch at Silchar, which is my hometown where I am staying with my mother. I can go to the local branch, punch the system and start the process. But that process never started. Either on 10.2 or on 21.2, that process never started. So there is no resignation at all. And what they have done on 8.5, my lords, is a knee-jerk reaction that look here, okay, the 3-month period is almost going. So let us get rid of this person and my lords, end the process. And whether, my lords, 8.5/2025, if your lordship sees, my lord, even at page 87, this is various conditions are there. Kindly ensure there are no pending staff accountability and disciplinary cases. When it is their admitted case, that is disciplinary case was pending at that point of time. Now I will show, my lord, that they have come up with a document in their affidavit in opposition showing that they have passed an order of censure, which is a minor penalty, albeit.
When?
On 15th of April. Without,
which was not served upon you.
no. Neither they have produced any document, any email, anything. And this is only, my lord, this is a backdated document which they have now gone to wriggle out of this issue, my lord. Because 8.5/25, even if one assumes for a minute that their acceptance is valid, it's a conditional one. That there are no pending staff accountability cases, nothing with disciplinary. So my lord, my humble submission is that the employer-employee dual relationship never ended. First of all, the resignation itself is not valid because it was not gone through the proper process as per the own circular of the bank. Please confirm exit interview is conducted so and so. All these things are there.
Okay.
Now, my lords, on the
Person with
last day,
disability is account devotion. Persons with disability. You go by the CCS rules, Mr. Nandi?
No, we have the.
No.
Own rules.
Yeah.
And nothing of the central government is followed.
So the bank has it, so I'll be praising lordship.
Just go through one thing. এইখন নহয় আৰু ইয়াৰ পিছৰ এখন আছে 2000 কিমানৰ এখন আছে হা এখন 96 হয় 96
but
নহয়
may I hand over the bank regulations, the relevant. It is
repealed by Rights of Persons with Disabilities Act. Yes.
Look, if I may first turn to my lords, Bank of Maharashtra Officers Service Regulations 1979, which admittedly applies, my lord. If I may take your lordship to regulation number 20. Lords, this deals with, my lords, the termination of service, my lord. We are concerned here with regulation 20 sub-regulation 2 and 3. I will just read out, my lords. If your lordship will have regulation, sub-regulation 2 of 20, my lords. An officer shall not leave or discontinue his service with the bank without first giving a notice of his intention to leave or discontinue his service or resign. The period of notice required shall be 3 months and shall be submitted to the competent authority as prescribed in these regulations. Provide further that the competent authority may reduce the period of 3 months or remit the requirement of notice. My lord, 3 months notice period, whether it would have come to an end. First of all, the issue is there is no resignation at all. That is my first submission. Second is that, my lord, whether the competent authority had reduced or waived at any moment. No, nothing done. Then we come to, my lord, regulation 20, sub-regulation 3. An officer against whom disciplinary proceedings are pending shall not leave, discontinue or resign from his service with the bank without prior approval in writing of competent authority in any notice or resignation given by such an officer before or during the disciplinary proceedings shall not take effect unless it is accepted by the competent authority. Now, my lord, we turn to sub-regulation 3, Roman 2.
Disciplinary proceeding shall be deemed to be pending against any employee for the purpose of this regulation if he has been placed under suspension or any notice has been issued to him to show cause why disciplinary proceeding should not be instituted against him and will be deemed to be pending until final orders are passed by the competent authority. So, my lord, final order, they say now that they have passed on 15/4, but that was never communicated to
Dulu Devi.
never communicated. So a pending disciplinary proceeding was there. The acceptance says that there will be nothing pending. So that acceptance also is not an acceptance, my lord, in the ILO. So, my lord, first of all, no resignation, which is a valid resignation as per the bank's own circular. Second, my lord, the bank's own regulations say that there has to be no DP pending, my lord. There was a DP pending. As far as I am concerned, it was pending. So now, if your lordship will turn to the 1976 regulations, my lord, the entire regulation does not apply, but I will just quote one part, my lord, to show that your lordship will kindly have regulation 17, my lord, that if an order of a penalty is passed, what is to be done? It deals with appeals. Look, if I may read, an officer employee may appeal against an order imposing upon him any of the penalties specified in Regulation 4 or against the order of suspension referred to in Regulation 12. The appeal shall lie to the appellate authority. An appeal shall be preferred within 45 days from the date of receipt of the order appealed against. So I have to, my lord, I have to receive it to challenge it. I have never received it. So the order of censure that was passed was never communicated to me. Now they are saying that on 15/4 we have done. Even, my lord, lordship will notice that the acceptance email, which was sent within half an hour of my lord's request for transfer, that also doesn't mention any pending proceeding or the fact that, my lord, an order has been passed. So, my lord, that is nothing but an eyewash on the part of the bank. Between 10/2 and 8/5, my lord, they did nothing. A question was put, my lords, by your lordships as to whether there is any counseling done or anything. There is nothing of the sort. I believe on last date, subject to correction, my learned friend made a submission that they have not accepted the resignation of 10/2, but they have accepted the resignation of 21/2. I believe that was a submission. But that will, in fact, take away their case in time. So, my lord, the
21 to also you are not able to punch in anything. Until date, you have not been able to punch in anything.
Because I am at Silchar, they have not enabled the HRMS. I am unable to do anything. So, my lord, there is no resignation as per the one submission. And yes, the submission of the other side that they can accept within the notice period. Yes, of course, that is right, my lord. The case, the learned Supreme Court has, the Honorable Supreme Court has held, my lord. I have already shown that judgment of PK Mittal that they can accept within the notice period, but effect will be from that 3 months period. To that extent, there is no issue with the stand of the bank. Yes, they can accept it, but they cannot say that, look, I'm accepting it in the month of, let us say, March or April. They can accept it. They will say, okay, yes, we accept it today. It will come into force, my lord, on the 9th or 10th of May. That they can do. But, my lord, whether the procedure laid down by the bank itself, as per his own circular, whether it was followed or not, whether there is a resignation in the eye of law. First of all, if there is so, my lord, whether there was an acceptance, whether there was any counseling done, whether there was any effort made by the bank to hold the hand, my lord. There was in one case, I was in the court, lordship had asked what is the holding of hands. The holding of hands, my lord, in this aspect would be, my lord, a person is under the duress. There is a law, my lord, there is an equity. A person is under duress, you are supposed to, here is the case, they say that, okay, he's asking for transfer. Let us, my lord. And the
expression of sympathy, empathy, understanding.
Absolutely. And the state is required to be, my lord, a model employer. And here a person is under duress. He's saying that, look, give me a leave. My mother is dying out there. And you say that, no. There is a time that, you know, these things are done. There's a manner of do. And here in this case, my lord, the bank's own procedure has been violated. So, subject to what my learned friend has to say.
Yes.
May I please the lordship? Before I take your lordships. Now, Lordship, this is the exit policy.
Ha.
My Lord has got it. I'll take your Lordship to 3.3. My learned friend was referring to various regulation. This is the exit policy of the bank, which my learned friend has also relied in the affidavit in this writ petition as well as in affidavit. I'll take your Lordship to paragraph 3.3 for a moment.
3.3.
My Lord has got it. Resignation. An officer can resign from the services of the bank by serving as a written notice of 3 months to the competent authority. So the period comes is 3 months. Now, how it is to be accepted, it is also written there. 3.3.5. My Lord has got it. The competent authority shall convey the decision. What decision? Either sanction or rejection on the request of the employee to resign within the notice period. So it should not exceed the notice period.
Then
it should not exceed the notice period. It should be within the notice period. Now, my learned friend was hammering upon HRMS. Here the resignation says by serving a written notice, not just say HRMS.
HRMS introduced later on.
No. This is Lordship of 16/6/2023.
And we are talking of 14/9/2023.
HRMS Lordship, I'll take your
on 14/9/2023.
Yes, I'll take your Lordship to the HRMS also. For a moment.
Yes.
Here is a resignation.
And then on the next page,
Background.
on the next page, the last lines on the next page. Not on the first page, on the second page. Employees concerned. Do we have the page?
No, I'm just page 3, Lordship. Just
No, we are at page 2.
Page 2.
Accommodate us also.
Yes, Lordship.
Page 2.
Yes.
Employees concerned are advised to take note of the above and process all VRS resignation applications through HR@1click only. This is issued on 15/9/2023 and issued on 14/9/2023. So even if it is a written communication on and after 15/9/2023, we are just making our mind clear what we understand until now, so that you may explain it later on also.
Just
anything done after 15/9/2023, written or otherwise, has to be done through HR@1 click. HR@1click only. No other mode allowed.
So far as VRS is concerned.
No, resignation.
Just why I'm saying, Your Lordship, Lordship will came to this one. Next page.
Okay.
Next page.
Yes.
Background. Why this is background. Voluntary retirement scheme is a program designed by the bank to offer employees an opportunity to retire voluntarily. Before their regular retirement, minimum service in the bank should be 2 years. Here is no word of just resignation. Eligible to apply for resignation is another program.
Now the word comes in.
Yes. Well, another program designed to offer to an opportunity to resign from the service at any stage. No minimum service is required.
Let us not waste time on that, sir. We'll be wasting time if we try to argue this does not apply to resignation, this does not apply to that. We'll be only taking time.
Yes. I'll take, just Lordship, it may come up tomorrow or day after tomorrow.
Why?
So far HRMS is concerned.
Huh?
HRMS.
We'll decide it.
Yes.
We'll decide it. No more time. Seriously, no more time.
Now, Lordship, so far as in my humble submission, Lordship, this resignation letter is valid. Now, Lordship, they have withdrawn. Their submission is that they have withdrawn.
They have not submitted it at all. Start with that. Show us an application in the that after 21/2/2025 or whatever, when he said that I am not being able to open HR at the rate one click, after several clicks, I have not been able to open it.
Yes.
Show us that you had a resignation in the proper format to take a decision on it. Number one. Number two, that the order of censure was sent to his email and he received it.
No.
His receipt, of course, he will not be able to show, but that it was sent through email. Otherwise, this court may come to a preliminary conclusion that it is actually an afterthought.
So far,
Where is that order, Mr.
Well, no.
Dulu Devi? Where is that order?
That is, that
Order made and kept
censure.
in the file. Order made and kept in the file is of no value. Dulu Devi, where is it?
175, Annex
Eh?
to H of their.
What am I asking you?
What?
In the case of Dulu Devi, the Supreme Court has said order made, kept in the file, not
Yes.
communicated, zero.
Yeah. It
Where
has
is
to
the
be
judgment?
communicated.
Where is the judgment? Use some IT.
Hello.
Find out.
Lordship, for a moment, I'll take your Lordship to this one. Page 172.
Page
172.
170.
Of my.
Oh, yes.
Confidential.
You have given it to him. No problem. Show
This
us
is
that the order was.
This is the findings of the inquiry authority, which was received by him, and he has not denied.
Yes.
And this is the findings.
We are on the order, sir, of page 175.
The findings of the, in his affidavit in opposition, what he has said, Lordship, in his reply.
Yes, yes. Does he receive it?
May I sub? Paragraph 14,
1/4?
page 182.
1/4, huh?
In-
Inquiry finding, we are not. We are not.
The inquiry findings itself is, Lordship, the finding says that the findings of the
So the
inquiry
disciplinary
committee
authority has
itself
given,
says
has held him
that the
guilty.
charges are proved against him.
We are not for a moment doubting the honesty of the inquiry officer in giving an opinion to the disciplinary authority. And the disciplinary authority, in the best of his wisdom, has given a copy to the petitioner.
Yes.
Please answer. He decides not to answer.
So far,
Let us assume for the moment he decides not to answer. What is the next stage?
we have communicated to him.
What is the next stage? To do what? After he does not reply to the communication, what are you supposed to do? Pass an order?
Yes.
After passing of the order, what is supposed to be done?
Lordship, that we have stated.
Copy. That order has to be communicated, sir.
Yes.
Show us the communication.
That your Lordship will find.
You may take a note of page 183, para 17, specifically said that I have not received the order at any point of time by any mode. You
And
decided
we have stated in
Huh?
our affidavit.
that it has been transmitted to him.
Yes,
by
we
what
have
mode?
We have stated in our affidavit number.
By what mode?
Lordship, I'm coming. Simply denying is all other documents he has received. He's
Uh-huh.
saying that this one he has not received.
Uh-huh.
This cannot be a ground law.
No, no. Shh.
Just to evade.
Page 90, page 142, para 19. You do not say that it has been communicated. The conservation right of persons with disabilities Act
Paragraph 15.
2016, 18, you know?
16.
Huh?
2016.
16. Call for it. Kindly call for it if you have got a assisting counsel. Call for it. Yes.
Paragraph 15.
1-5.
Yes.
Yes.
The petitioner states that before the inquiry officer, the preliminary hearing was attended by the presenting officer and the petitioner through online mode.
You are wasting our time, sir. I'm asking you, show us the sentence that the copy of the orders passed in the disciplinary proceeding had been served upon him. Do not take us to the inquiry order.
That is here. The deponent's
it is not
that the finding of the inquiry was served upon the petitioner.
Sir, if you are not understanding what we are trying to say, let me explain it again. I will explain it again. See, there are two forces acting when a thing goes round and round. When it does not go in a straight line, two forces act. One pulls it to the center. The other pulls it away from the center. Therefore, it goes round and round. Is it not?
Got.
Now, we have the attitude of straightening it out.
That is what I'm...
Show us that the order has been served. Para, again I'm telling you, page 142, para 19 is where you talk of the order. Prior to that, you're talking of the inquiry.
Page
142, para 19 is where you introduce that order passed against the petitioner that you are now being afforded a censure. And you take care to not to mention that it was sent to him by any means before the purported resignation had been accepted. There is a fault in our prima facie view that the bank may not have acted in correct procedure of law. We are not imputing any other means. We are just saying that it may not have been done correctly. And we hope Mr. Nandi is not trying to support.
No, what I am submitting.
We know him to be a better man.
What I am submitting, Lordship, it is specific statement. The deponent states that the finding of the inquiry, what my lord has was served upon the petitioner.
Yes. Yes. He accepts it. And I will go to the extent of saying that he may or may not have answered it. Does it conclude the disciplinary proceeding against him? No. It is just an inquiry report. Now, what is an inquiry report? Service law. We can assure you it has been held to be only a opinion based on the conduct of the proceedings. And in fact, there have been several judgments of the Honorable Supreme Court saying inquiry officer should neither point out the guilt or the amount of penalty supposed to be leveled upon the accused delinquent. He is supposed to be a neutral person sitting there taking statements, allowing cross-examination. And end of the day, he may say that, okay, I think he's guilty. That much. Nothing more. Then that inquiry report has to go to the petitioner. You say it has gone. He admits it is gone. He received it. Now what happens? Now the order of penalty. He either answers it or he does not answer it. Now the order of penalty. So-and-so, you are guilty. Finished. I can punish you with this much. I'm giving you this much censure. Keep quiet. He kept quiet. Now, that order is in the file. It needs to go to him. Did it go to him? If it did not, what does Dulu Devi say? So on the date you accepted the resignation, what happened? There was a disciplinary proceeding pending. Therefore, your order says we accept it, subject to disciplinary proceedings. Please find out. Right? So therefore, conditional acceptance of resignation. Conditional tendering of resignation is not allowed. Conditional acceptance, of course, not allowed. No resignation in law. Now tell us. If we are wrong, just point out that this is the document. Let me assure you one document against this. We close the writ petition, dismiss.
For service of this one is concerned, censure is concerned.
Not done.
Admittedly, there is no document.
Now, we will tell you what happens. When services are terminated, the status of a delinquent as a government servant comes to an end, and nothing further remains to be done in the matter. But if an order is passed and kept merely in the file, it would not be an order, nor shall the said order deemed to have been communicated. If the order is kept to yourself, there is no order in law. Suppose we take this inside, we dictate all the order, big orders, and then we keep it there. It is not there in the CIS. There is no certified copy of it. The petition is pending.
I got your lordship. What my lord is posing question is that
And the third thing is his prayer to be granted some benefit, being the caregiver of a disabled parent. Was it considered at any point of time?
lordship, that matter I'm lordship.
Supreme
he
Court
was-
has time and again said,
yes.
if
He
there is
was posted in the Northeast and he was continuously in the Northeast for more than 13 years. For more than 13 years. Since his joining in the, now the transfer policy of the bank says that in one place, he should not be more than 6 years. He was in for 13 years. After promotion only, for 2 promotion he was given. Even after first promotion, he was in the Northeast and in the Gauhati. In the second promotion, he was in the Northeast for certain period of
show
time.
us that the mother of the petitioner
Yes.
was a product of his service rendered to the bank. The disability arising to the mother was a product of this service which the petitioner has rendered to the bank. It is not. Therefore, the disability of the mother and he becoming a caregiver, whatever past he had done with the bank, we do not say that he cannot be moved out. Even the Supreme Court judgments say that yes, service exigencies would require relocation. So many things would be required. But is it necessary to take into consideration that particular factor, that he's a caregiver, and disturbing him will disturb the rights of a disabled person under the right of disabled persons with disability, that it disturbs that right. And in such circumstances, even though it may disturb the mother, the exigencies of service require you to go and join, sir. Please go and join. We are sorry. Was it done?
Lordship, so far his joining is concerned, he has joined in Dehradun after long period of time.
Keeping his
He was
mother
given
here.
leave from time to time. He was in Dehradun just for a short period of time. Time and again, he has left Dehradun without even informing the authority concerned. And that is what the disciplinary proceeding is. Even without informing the authority, he has left the job. So that aspect of the matter, I'm not agitating. I'm not coming to that why disciplinary proceedings. But the fact remains that he has joined in Dehradun. Now the transfer policy says he can be repatriated to his parent position only for 3 years. It is his application, lordship, is for request transfer. His application
has it been rejected?
Not at that point of time, lordship.
Had it been rejected?
we have specifically stated, since you have given resignation letter and that has been accepted and you are
Kindly-
not in service. So
Kindly, since this is the day we are disposing of this repetition, this will no longer be important for this case, at least, but otherwise, kindly find out, because it will help your bank also as a service, as an employer, the relevant law regarding the caregiver of a disabled person.
I'm just saying.
Every policy made, promotion,
It's in the bank.
entry into
policy.
service,
Transfer-
everything done.
It's in the bank.
Once a person with, what do you call it? What disability do they call it? Certified disability. No.
Specified disability.
Specified disability.
Specified.
Once that comes in and a person becomes a caregiver,
Gotcha.
the whole world
it's there in
changes.
Clause 6, specifically 6.2, which I am relying upon, of the bank's policy. It's at page 126 of the bank's policy, which would act as an exception to the general policy of transfer.
So, sir, two of your defenses, one that the HR at the rate one click was not required to be depended upon in case of resignation, that we find to be not correct, going by the circular of 14/9/2023. Your second thing, that the order of censure was made known to him.
Lordship, this is the transfer policy of the bank. That is on 19/4/2025.
What does it say?
Officers applying for transfer as a repartition to their previous zone. Here also in the same, he has applied for repartition to the previous, will be eligible for applying request transfer. He is applying for request transfer only after completion of a term of minimum 3 years of active service in the present zone. That is,
Sir, in
request transfer. He has applied for request.
in just common language, a person pays for bail because it is a bailable section, and then the police go and add one non-bailable section to it. Does it change the entire color of the litigation? Yes, it does. This policy is common for all. No difficulty in that. Just one word added, and that is what his email says. I need to care for my disabled mother. That would change the entire color of the transfer policy to be made applicable to him because of the Right of Persons with Disabilities Act, giving a special status to the caregiver. I was asking for that act. It has somehow become invisible to this court.
Even
2018 নাই পোৱা এতিয়ালৈকে। Print out দিবলগীয়া হৈছে, hack.
I've given the book also.
Lordship,
There's a book
regarding
here.
transfer. Regarding transfer.
The moment,
Whether this honorable.
no, the right of the disabled person is, you have also come back with it. Where is the repeal, the new act? This is the 1996 act.
I think my associate has got it from the other court. It is fine.
Ah,
Anyway, the
2016 act is what we need. See, the 2016 act has given a privilege to the disabled person that he will not be denied the presence of his caregiver. Therefore, the Supreme Court in transfer cases have said, transfer him. Accommodate the disabled person with him in a manner where he can serve and take care. Right? So when he said that I have a mother, take me back, was there a suggestion? Will accommodate, go there. That compassion, which is now a legal binding, did not come. And you cannot say that the Right of Person with Disabilities Act does not apply to the bank. It has to. It has to apply. They have to give a ramp. They have to give it in braille if asked for. That is what the Right of Persons with Disabilities Act requires. That caregiver part was not even looked into. We are not going to decide the repetition on that part. But yes, it will have these colors when we decide the issue. That what was the predicament of the petitioner. We do not want you to be caught unawares. Huh? This is what we were asking for, na? '95 Act did not have it. Now 2016 Act says caregiver means any person, including parents and other family members, who, with or without payment, provides care, support, and assistance. Then later on it says, he shall not be denied access to the caregiver. I forget the particular provision.
No, section 2R is also there. 2R is also there. Person with benchmark disability.
That is okay, but that he will not be given the caregiver cannot be taken away from him. These are things which he had put before the bank. That, sir, my mother is disabled. Please accommodate. And when I told you that the Honorable Supreme Court has interfered in some matter, remember, I forget the name, that matter, it was a matter of an army personnel who was transferred. Discipline had its stop.
Disability certificate is concerned. The petitioner has applied for disability certificate on 29/5/2025. But in the writ application, I did not find the disability certificate. It is.
No. We are not even saying that his parent may be or may not be. We are not on that. We are saying he says, I have got a disabled parent. I need a posting. Did you consider it? Reject it. There is a right to reject. Was it considered? In the right to due. There is an order of Justice Sham, if I'm not wrong, interim order, which says that when a man comes to say that I need to give care, don't transfer me, he's not crying for himself. He's crying for that disabled person who cannot cry for himself in the court. And therefore, the court will now look into it. So all said and done, on the merits of the case, we do not find that where is that? After this review of the exit policy, this OM had come requiring the resignation to be submitted through proper channel. Therefore, he had again and again requested you for the channel to be opened, which displays his mind that he had the intent of resignation. But for the resignation to take place, there has to be a definite document placed before you which can be considered. That document not being placed before you for whatever reasons, your decision on the intent to resign could not have been taken. The disciplinary proceeding which now you have taken up in this petition, the order never being served upon him, in the opinion of this court, would mean that that order did not exist qua him. On the date the resignation, if it can be so called, was accepted, being a qualified acceptance of a resignation letter. The resignation letter would, or the acceptance would itself fail in law. Therefore, the acceptance of the resignation goes. He never filed a document for resignation through proper channel, but with the intent being there, although he'll be reinstated in his services, the period of absence would be left to you to decide. Up to the date, you had accepted the resignation. Since after the resignation, he has been forcefully kept out of duty without there being any fault on his part, he'll be entitled to the salary and allowances, which he would have been otherwise been entitled to, minus whatever allowances he would have actually earned if he had rendered services. The TA, etc., he will not get. The basic he will get. And the disciplinary proceedings, since qua you have already passed an order of censure, will not be now reopened. And he would be at liberty to file an appeal within 45 days. Of the passing of this order against that order of censure, which will be considered in accordance with law. That is the best he would have.
since my lord is coming to the conclusion that he is due to employ, the order of resignation does not hold good. That means he is an employee. That parent. And he pretends himself to employee. Now, Lordship, even assuming he did not receive the order of censure, assuming for a moment, but from the affidavit in opposition, he has received the affidavit order of censure. But even thereafter, he did not file appeal. So
you don't want us to give him that liberty to make an appeal. Okay. Don't.
That 45 days is already gone. Even
It was
assuming
only
he
in
did
the
not receive.
it was only in the interest of justice we said he could file an appeal within
But
45
that
days of.
45 days is already because
Yes, it was in your knowledge once the affidavit was filed.
I leave it to your lordship. That I cannot urge a point which perhaps should have come earlier. But the fact is that even if we accept the order of censure, that order of
Your career
censure,
doesn't suffer in any manner.
lordship, it cannot
Minor
be
penalty.
deemed into effect on that day, 15/4/2025. That order of censure would not have any effect on this.
On the date of the filing of the affidavit in opposition, it will come into effect. We will not go into so much. We will not go into so much technicalities. It will give rise to grounds of. Let us not say what.
Two minor points, Milord. The banks, perhaps, if I may have skipped, Milord, the bank's transfer policy incorporates the disability.
Person with
Yes.
so that is
there.
that we have taken into account only to see whether, because of whatever has happened,
Lordship.
did you suffer?
Lordship.
Because the authorities did not take into account that part of the matter.
Yes, because clause 6.2 is.
That is only for the grant of the quantum of relief we can give to you. That part not having been there, the relief would have been something else. But here is a case where you officially told them that I have a mother to take care of, and you have been taking care of your mother, presumably if she is alive. God keep her alive. But presumably if she is alive, you have continued to take care of her. So that is one part playing in the mind of the. Yes, we'll dispose it off. Heard the learned counsel for the parties. Arguments concluded. Judgment reserved.
So there's one order of the Allahabad High Court. Perhaps only for your studies.
And any written argument, if you want to give both the counsels, if you want to give a written argument, have it given before Friday.
Lordship.
We want to utilize a day.
Written argument and some citations also.
Whatever you want to give. But if those citations are something which will interfere in what we have just spelled out in court, that this is how we will dispose it, we will not take it into account.
Lordship.
Because that will be again changing our judgment. We will not be able to do that.
Obliged.
Thank you. I can save you. Cool.
Again, 42.
He doesn't.
My lord, I have challenged my lord, page 77 page. Letter parting. And due to long, my lord, legal, I think, my lord, that this honorable court passed the order, my lord, whereas hereby remanded the matter to the, my lord, Bank Authority. Kindly see page 75. Page 75.
Page 75.
75.
What does it say?
Paragraph 30. On operative portion, paragraph 31. That being the position, court is of the considered opinion that impugned order dated 18/11/2008 cannot be sustained and is accordingly set aside and squashed. Matter is remanded back to the disciplinary authority to pass fresh orders having regard to all the relevant facts and circumstances of the case and in accordance with law, keeping in mind the observation made above. While passing the said order, the disciplinary authority shall bear in mind the long litigation history of the case and fact that petitioner is about 75 years of age now. Let such a fresh decision be taken within a period of 3 months from the date of receipt of the certified copy of this order, which shall be communicated to the petitioner. And thereafter, impugned order passed, my lord. Page 17, by only amount of gratuity and amount of leave salary has been paid, my lord. Amount of leave gratuity and amount of leave salary paid, my lord, but no back wages has been sanctioned. Page 77, my lord. Second paragraph. In terms of the aforesaid order, the bank has decided to review the earlier order dismissing you from the service of the bank. Accordingly, it has now been decided that since you had reached the age of superannuation on 28/2/1998, the question of reinstating in service does not arise. However, for the purpose of giving full superannuation benefits, you shall be notionally treated to be service until you had reached the age of superannuation on 28/2/1998 on the date of your earlier dismissal from service 10/10/1987. Further, considering that no service was received by the bank during intervening period from the earlier dismissal from service dated 10/10/1987 up to attaining the age of superannuation, that is 20/2/1998, no back wages shall be paid.
What is wrong?
What is wrong? Kindly see page 75. This honorable court, while setting aside the impugned order, nothing so say about the misconduct of the petitioner. And due to long procedure, and he is debarred from service, and ultimately impugned order passed that no service benefit has been received, paid. On last occasion, this honorable court, seeking some clarification from the bank,
What?
regarding paragraph number 30 of page 75, page number 75. The earlier order.
We had asked for some instructions. Okay. Yes, what is your finding on his guilt?
No finding, my lord.
You ask the questions, we will only hear the answers, yes. The question is to him, your answer will not help.
The letter reveals
That
he
is guilty or not guilty?
The annexure page 77 does not reveal anything, my lord.
Is he guilty or not? No. No, when you don't say someone is guilty, what is the presumption in law? Not guilty.
It's not guilty.
He is not guilty. If he is
tell
not
us the letter.
guilty, why was he out of service? Because of your wrongful orders. If it is because of your wrongful orders, can you withhold the salary minus the allowances which are related to actual service? Can you do that?
No, that cannot be done. Yes, madam, that very line.
Part hard, full hard.
However, however, for the purpose of giving superannuation benefit, you shall be.
So you are giving the full superannuation benefit.
Yes.
Not guilty.
Not guilty, my lord. No,
Not guilty.
No, not guilty. The letter reveals so. If we go fall back to that Dipali judgment, my lord.
Dipali Kundu Survase.
Yes.
The moment he says that I was not earning anything.
It was because of our conduct he was out of service.
Not only that, Dipali Kundu Survase says that he has to state before you that I was not engaged anywhere.
My lord.
You will make a short inquiry whether he was otherwise engaged, employed. Can you do that now after 1998?
Has passed away.
Let us not then.
This person has passed away.
Then let us not go into that aspect of the Dipali Kundu Survase. We will simply say that no guilt has been recorded.
My lord.
And if no guilt is recorded, then we have to presume that no such finding has been arrived at. The manner in which the period of absence from the date of termination of service till the date on which you would have superannuated could only have been decided by the respondent authorities if there was some finding of guilt against the petitioner. Since none is there, the simple and plain law regarding the
Back wages.
back wages, that is, unless a guilt is there, he is entitled to the back wages will follow. Therefore, he is entitled to the back wages for the period from the date of his termination to the date of his superannuation, which shall be paid within a period of 3 months from the date of. Oh, we have not written the earlier part of the order. Yes, do that. Man has been fighting from 1990.
Yes, my lord. Let this widow have some. He has passed away.
He has passed away.
Passed away.
Substituted.
28-1.
Substituted.
Why? Died on 28-1-2018.
Huh?
During pendency of the writ petition, my lord, died. Died on
30. Why was it pending for so long?
2017, my lord.
Why? For 8 years it was pending?
My lord, no affidavit has been filed, my lord.
Huh?
No, affidavit asserted.
And last file on, my lord, receipt, I have received 3/3/2025.
No, my lord, the issue is on this side, we know we are wrong, but nobody has sit to it. That is the reason, sole reason behind this being carried with these years, all these years. Because the letter doesn't reveal. He was notionally
It was
in service, so it says no guilt.
Immediately on service of notice, the matter could have been.
My lords.
Heard Mr. K. Patgiri, learned counsel appearing for the petitioner. Also heard Mr. D. Gogoi, learned counsel appearing for the Assam Cooperative Apex Bank Limited. This writ petition is the third round of litigation
But ninth round.
for the
Ninth round of
litigation for the deceased husband of the present petitioner who has substituted the earlier employee of the Assam Cooperative Apex Bank Limited. Full stop. The writ petition was filed on 4th of August 2017, and the original writ petitioner made his demise on
28-1-2018.
18. Full stop. Later, the wife of the petitioner has been substituted as the petitioner. This order at page 72, does it record all the earlier litigation by him?
Entire.
The petitioner had joined, the husband of the petitioner had joined services in the Apex Bank on 8/11/1957 as an assistant. He was allowed to work as a branch in charge of the Patshala branch during his service tenure. You can take your seat, Mr. Patgiri. On 15/11/1986, the petitioner was served a show cause notice asking reasons as to why a disciplinary proceeding should not be initiated against the petitioner on the allegations of misconduct leveled upon him through the aforesaid show cause notice. Which I don't write now, huh? Where is that show cause notice? Can you show us?
But I have not annexed ballot, but I have annexed the ballot first order, court order, my lord.
Huh?
First court order, page 15.
Okay, let
15, my lord, page
Let
15.
it be. The petitioner was dismissed from service on 10/10/1987, and both his appeals filed to the board of directors as well as to the administrative council were dismissed. The petitioner approached this court in Civil Rule 777 of 1992. It was disposed of directing reconsideration of the appeal filed by the petitioner. Again, the appeal filed by the petitioner was rejected. By the board of directors. Civil Rule 3341 of 1996, filed thereafter by the petitioner, was disposed of by this court by the order dated 26/11/1998, requiring the administrative council to decide the appeal preferred by the petitioner. The appeal filed by the petitioner was again dismissed. The petitioner raised an industrial dispute which led to the registration of reference case number 16 of 2001 before the Labour Court at Gauhati. And upon contest, the learned Labour Court had passed an award holding that the petitioner was not a workman, and therefore the reference was not maintainable. However, the learned Labour Court had taken a view that the dismissal was justified. The petitioner approached this court again by filing WPC 1306 of 2005. Don't write now, huh? Mr. Gogoi. See the predicament of this man. Civil rules became writ petitions. He was still fighting it out.
Yes, madam. Unfortunately.
Huh? The petitioner again approached this court by filing WPC number 1306 of 2005. And by the order dated 27/11/2007, this court held that when the Labour Court had come to a conclusion that the petitioner was not a workman under the as required under the relevant provision of law, the Labour Court had committed error when it decided the merit of the reference. Full stop. This court further held that the dismissal of the petition was to be vitiated because of the violation of principles of natural justice, since the inquiry report had not at all been furnished to the petitioner. The matter was remanded back to the Apex Bank to recommence the disciplinary proceeding from the stage of submission of inquiry report. It was further directed that the recommenced inquiry should be completed within a period of 4 months from the date of the judgment. Yes, where is that date of the judgment? 27/1/2000, 27/11. 2007. The managing director thereafter wrote to the petitioner by furnishing a copy by letter dated 23/2008. At this stage, this court notices that the enquiry report had been supplied to the petitioner even after the period of 4 months. Is it? Or no? Had been furnished to the petitioner. No, strike out the sentence, huh? The petitioner filed his reply on 4/4/2008. And by an order dated 26/7/2008, the petitioner was found guilty in respect of all the charges, and the bank proposed to impose the penalty of dismissal from service as per Rule 46A(6) of the staff rules of the bank. The petitioner was asked to show cause against the proposed penalty. At this stage, this court takes into account the fact that the time limit given to the respondent bank by the order dated 27/11/2007 had expired on 27/3/2008, and proceedings thereafter, as has now been settled by the Honorable Apex Court in the case of so-and-so, could not have continued, and the petitioner deserved reinstatement service at that stage itself. Next para. Considering the reply of the petitioner, the petitioner had taken up this ground by filing WPC number 4693 of 2008, seeking reinstatement in service with all consequential benefits. However, this court, noticing that the departmental proceeding had thereafter been completed, this court held that the grievance raised by the petitioner did not survive, and since and by order dated 2011/2008, the writ petition was closed without expressing any opinion on the order dated 18/11/2008, giving liberty to the petitioner to challenge the legality and validity of the said order. The petitioner preferred an appeal before the division bench against the judgment of this court dated 27/11/2007, passed in WPC 1306 of 2005, which was registered as writ appeal number 69 of 2009. However, the said appeal was dismissed for non-prosecution. Application for restoration of the writ appeal was also dismissed on 16/8/2012. Hence, thereafter, the petitioner filed WPC 4693 of 2008. Is it? No. WPC 5421 of 2012, challenging the legality and validity of the order dated 18/11/2008. This court, by the order dated 22/3/2016, found that declared as follows, from page 75, para 30, para 31. Okay. The fresh decision was to be taken within a period of 3 months from the date of receipt of a certified copy of this order, of the order, full stop. When did you take this decision, sir? What is the date of this order? Page 77.
And then no date has been
No
tested.
date, my lord.
Huh?
No date is reflected.
It is communicated for register post.
He received it on 15/6/70.
There is no pension for this bank employees.
Pension, no pension, man.
No pension. Okay. And we do not know the date of this order.
It was blank, but it was received on.
Received by the petitioner, acknowledges my lord, and 50, page number 11 of the petition, 15/6/17.
15/6/2017. Did you prefer any contempt
No.
petition before you received this order? No.
No.
Have you made any statement here? When did you serve a certified copy of this order
No.
on the bank? Any statement anywhere you have made? When did they received it?
15
Huh?
to 3.
Paragraph 16.
Somewhere we can find.
Paragraph 15, my lord.
It is submitted before the respondent bank. When? See, there are two aspects.
No.
3 months from the date of receipt. 3 months from the date of receipt, no decision is taken. The entire proceedings go. Is it not? That order simply goes.
Yes, my lord.
Beyond 3 months, without leave of the court, you cannot take a decision. Is it not?
2017. Order dated 22/3/2016.
Yes.
Ah. 3 months from the date of this receipt of a certified copy of the order. Hai na? Full stop. It is the case of the petitioner that thereafter the bank had passed the undated letter issued by the managing director Assam Cooperative Bank, Cooperative Apex Bank Limited, on which was received by the petitioner on 15/6/2017, whereby the petitioner was to be notionally treated to be in service until he had reached the age of superannuation from the date of the earlier dismissal from service, that is 10/10/1987, and further considering that no service was received by the bank during the intervening period, no back wages were required to be paid to the petitioner. Bank has gone. The bank therefore entitled the petition. The bank therefore held the petitioner to be entitled to superannuation benefit to the amount to a total amount of rupees 2,82,757. Full stop. This order is under challenge in the present writ petition. The respondent bank has filed an affidavit in which, having reiterated the facts leading up to the present litigation, the bank had decided that since the bank has stated that the petitioner having not been reinstated and since no service was received by the respondent bank during the intervening period from 10/10/1987 to 28/2/1998, no back wages was required to be paid to the petitioner. a reference to the staff rule number 46C has been made. However, it has not been projected as to for what reason such staff rule has been quoted, full stop. This court has heard the submissions of the learned counsel for the contesting parties and has also gone through the different documents annexed to the writ petition and the submissions made in the affidavit filed on behalf of the Assam Cooperative Apex Bank Limited through the managing director. Full stop. Next para. This court notices that the undated letter, which is under challenge in this writ petition, does not find and does not record any finding of guilt against the writ petitioner hearing. Original writ petitioner, oblique employee of the bank, and merely records that since the petition, since the employee of the bank had not rendered service during the period from his initial date of dismissal up to the date of his attaining the age of superannuation, he would not be entitled to the arrears of salary for the intervening period. Full stop. This court, by the order dated 2016, 22/3/2016, had remanded the matter back to the disciplinary authority to pass fresh orders having regard to all the relevant facts and circumstances of the case. Full stop. This court had observed that the disciplinary authority has to give its own findings on each of the charges framed against the delinquent, which must be supported by cogent reasons, and had further observed that in the present case, to the impugned order of dismissal, which was set aside, no such cogent reasons were discernible. Full stop. Be that as it may, the order which has decided not to give any back wages to the husband of the present petitioner, who was the employee of the bank, does not record reasons except that the bank had not availed the services of the husband of the petitioner for the period from 10/10/1987 to 28/2/1998. Full stop. Next para. In this regard, the notice of this court. Under this court notices the law laid down by the apex court in the case of Dipali Kundu Surwase. I'll give you the citation later on. Dipali Kundu Surwase, which had taken into account the different kind of situations in which an employee, on reinstatement, would be entitled to the back wages and arrears. Full stop. In the present case, it has been repeatedly held by this court that the orders which terminated the services of the husband of the present petitioner, employee of the bank, had suffered from different illegalities, though the same may have been in the procedure adopted by the disciplinary authority, on one occasion, the enquiry report was not given to the petitioner, to the husband of the petitioner, before imposing a penalty on him. And on the next occasion, the disciplinary authority failed to give cogent reasons for coming to the decision that the petitioner, the husband of the petitioner, deserved to be terminated from his services. Full stop. In the final order, which is now being challenged, no opinion of the disciplinary authority has been given regarding the guilt of the petitioner, but as fairly but in the opinion of this court, comma, as has also been fairly submitted by the learned counsel for the respondent, comma, the respondents had deemed it fit to give full superannuation benefit to the petitioner by taking him to be notionally in service, full stop. In the opinion of this court, when the respondents had the intent to grant full superannuation benefit to the petitioner, comma, they were conscious of the fact that no penalty had been imposed upon the petitioner, and therefore it is obvious that the guilt of the petitioner had not been decided upon by the respondent authorities, or at least it was not decided against the petitioner to his detriment, full stop. In such view of the matter, and in view of the law laid down by the apex court, comma, this court is of the considered opinion that the back wages of the petitioner for the period from 10/10/1987 to 28/2/1998 cannot be denied and or withheld by the respondent authorities, since this is an appropriate case when this court can hold that the termination of the petitioner was not in accordance with law and the petitioner had been deprived the opportunity to offer his services to the bank because the bank had illegally kept the petitioner away from services through illegal orders passed on 10/10/1987 and on at least one occasion thereafter, full stop. In the above view of the matter, it is hereby directed that the respondent authorities shall be under a legal liability to pay the petitioner the arrear salaries for the period from 10/10/1987 to 28/2/1998 to the petitioner. However, without the allowances which were required to be paid upon actual delivery of service. The aforesaid period of the petitioner has already been held to be in notional continuity for the purposes of other pensionary benefits, full stop. The amount to which the petitioner now would be entitled, comma, since the husband of the present petitioner, who was an employee of the bank, has superannuated, comma, shall be calculated and paid to the petitioner herein within a period of 45 days from the date of passing of receiving a certified copy of this order, full stop. For this purpose, the petitioner shall appear before the managing director of the Assam Cooperative FX Bank Limited on or before the 10th of March 2026 with a certified copy of the orders of this court, and upon such receipt, the managing director, Assam Cooperative FX Bank, shall start further proceedings to make the payment, full stop. Upon making the payment, the managing director, Assam Cooperative FX Bank Limited, shall file an affidavit of compliance before the registry of this court, full stop. In case no such affidavit is filed, affidavit of compliance is filed on or before the, we said 45 days, na? 1, 2, 3, 4, 5, 6, 6 and 31 is 37, 38, 39, 40, 41, 42, 43, 44. On or before the 20th of July, 20th of April 2026, comma.
In that case, can I get a further 15 days window, madam?
Yes, from 45 make it 60. Will do?
Madam.
So that will be 31 and 30 is 61 days. We've got another 8 days here. On or before the 2nd of May 2026, the matter be relisted before this court on the 6th of May. Full stop. In case the affidavit of compliance is filed, no further action requires to be taken by the registry on this petition.
Okay.
Unless that if it comes, it will come back again to this court.
Amount of gratuity and lip income to required to be.
ऊपर लिखिएगा ना, एरिया चले रहा ना, उसके साथ लिखिए. The amount of gratuity and leave encashment shall be
Recalculate already, but length of service, my lord. It is not.
Length of service is calculated. Notionally, you have been given. Why are you confusing us? All you will get is the salary. You are confusing. Notionally, they have taken you to be in service. Therefore, they have calculated it as if you were in service on that day. You are only supposed to get the salary for those 87 to 98, 11 years.
11 years.
11 years. Go and get that. If it is not, if there is no affidavit of compliance, it comes back to us.
Well, I'll see to it.
Obliging.
May I please, Honor? Lordship, this particular criminal revision petition has been filed by the appellant upon being aggrieved by the judgment and order dated 29/8/2011 passed by the learned judicial magistrate first class Kamrup in CR case number 797 of 2009 under section 138 of Negotiable Instruments Act. Lordship, the order of the learned JMFC, that particular order, the learned JMFC have stated that the cause of action arises only after the dishonor of the check for the first time, and another cause of action would not arise after repeated dishonors in view of the Honorable Supreme Court judgment in Krishna Export and others. Lordship, in regard to that, I would like to furnish a judgment of the Honorable Supreme Court that has been passed on 2013 in Kamlesh Kumar versus State of Bihar, Your Honor. Lordship.
Where is your opponent?
See, I'm not aware of that.
Oh. Was anybody, was SR Bhattacharjee, GS Bhattacharjee? Oh. Yes, what does the judgment say?
That's it.
Yes, what does it say? Which line?
Yes, Lordship. Lordship, may I draw your kind attention towards page number 11, paragraph number 11, Lordship. Lordship, it is thus clear that period of limitation is not to be counted from the date when the check in question was presented in the first instance on 25/10/2008, or the legal notice was issued on 27/10/2008, inasmuch as the check was presented again on 10/11/2008. For the purpose of limitation, insofar as legal notice is concerned, it is to be served within 30 days of the receipt of information by the drawee from the bank regarding the return of the check as unpaid. Lordship,
After the check is returned unpaid, notice has to be issued in 30 days. That is the period of limitation provided for issuance of looking upon the drawer of the check to notice this. Check was presented second time on Iman, complainant having sent the legal notice Iman, much after the expiry of 30 days. In that case, it was after the expiry of 30 days. Hai na? From 10/11, he should have sent it within 10/12, approximately. Okay. Yes.
Lordship, in this particular case, that is Kamlesh Kumar, in this case, when the check was issued, after that when he dropped it for the first time, thereafter there was a legal course. Notice was served, but no complaint petition was filed, as because there was an understanding between the duo. Later on, again, the check was deposited in the bank, but thereafter they made a delay. That is, after 30 days, they filed the complaint petition, and that is why that this particular criminal petition has been quashed, Lordship. But in our case, coming to the
After
facts
the
of-
second time, you had given the legal notice within 30 days.
Yes, Lordship.
And therefore, you said that it should have been allowed to continue.
No, Lordship. In our case, coming to the facts of the case, Lordship.
Bolliye.
Coming to the facts of the case.
Yes.
Yes, sir. On 25/11/2008, previously, Lordship, on May 2009, the respondent number 1 took a credit of rupees 1 lakh from the appellant hearing with a promise to return it back after 1 month. After 1 month, on 25/11/2008, he issued a check of rupees 1 lakh to the appellant hearing. The appellant deposited the check and it was bounced back, Lordship. On 30/12/2000, in between this period, between 25/11/2008 and 30/12/2008, there was an understanding between the two that he will pay the same with in cash or other. Okay, but on 30/12/2008, the appellant hearing served legal notice to the respondent number 1. Again, Lordship, on 12/1/2009, the respondent number 1 sent a letter to the appellant hearing requesting the appellant to deposit the check after 25/1/2009. Lordship, the respondent number 1 has acknowledged the same. As per the request,
So instead of giving you a fresh check, he has asked you to deposit that
Yes,
very check again.
Yes, Lord.
Okay,
And
then?
the cause of action arose from the date when the check was deposited for the second time, Lord. But the learned JMFC has contended that cause of action arises only after dishonor of the check for the first time, and another cause of action would not arise after repeated dishonors. Lordship.
No, repeated dishonors, even if it does not do so, in this present case, perhaps, since we are requested to deposit it again, a fresh cause of action had to arise. Instead of giving you a fresh check, he has asked you to deposit it again.
Yes,
So this becomes a fresh check.
And accordingly, Lordship, after depositing the said check for the second time, the legal notice was served within that particular 15-day stipulated period of time. And after expiry of that 15-day stipulated period of time, complaint case was also filed. But the respondent number 1 on 4/1/2011.
Now, this case that in the case that you have shown us.
Yes, Lordship.
In that case, after the first bouncing, they had not given any notice.
They have given any notice, Lordship. Lordship.
Yes.
Lordship, paragraph number 6, Lordship. The check in question was presented on 25/10/2008. After it was dishonored, complainant issued notice dated 27/10/2008 to the appellant. The appellant did not accept the demand contained in the said notice. Even the complainant chose not to file any complaint under section 138 of the NI Act at that time. Instead, he presented same very check again for encashment through his banker on 10/11/2008. It bounced this time as well because of insufficient funds. Another legal notice dated 17/12/2008 was sent to the appellant. As this legal notice also did not invoke any positive response from the appellant, this time the complainant filed the complaint dated 7/1/2009. The period of time, Lordship, filing the complaint petition after the bounce of the check for the second time. That was the reason in this case, the complaint, the petition was dismissed. Lordship,
What are these two cases, Krishna Export and Sadanandan?
Yes, Lordship, in Sadananda, Lordship, in Sadananda Bhadran versus Madhavan Sunil, the issues that were raised was that the check was not for discharge of any debt or liability, and further said that when once the check is issued, the presumption is in favor of the complainant that the check regarding discharge of the liability, and it is for the applicant to prove the contrary.
Just give us 2 minutes, we'll come back, huh? Give us 2 minutes, we'll come back.
Lordship.
The lower court.
Lordship, yes.
But you were showing us the judgment. What happened to it? What was the judgment?
Lordship, in this particular judgment,
Yes?
yes, Lordship, there is a question that has been determined. The question is whether the payee or holder of a check can initiate prosecution for an offense under Section 138 of the NI Act for its dishonor for the second time if he had not initiated any action on the earlier cause of action. Lordship, to this question, the three-judge bench of the Supreme Court has stated that what is important is that neither Section 138 nor Section 142 or any other provision contained in the Act forbids the holder or payee of the check from presenting the check for encashment on any number of occasions within a period of 6 months of its issue or within the period of its validity, whichever is earlier. That such presentation will be perfectly legal and justified was not disputed before us even at the bar by the learned counsel appearing for the parties, and rightly so in the light of the judicial pronouncements on that question, which are all unanimous.
Show us that.
Lordship, paragraph number 8. Lordship.
Give us a copy.
Lordship, I have given.
This one. Kamlesh Kumar.
Yes, Lordship. Yes, Lordship. Paragraph
Kamlesh
number
Kumar.
8, Lordship. Page number 8.
Paragraph number
8, Lordship. Lordship, in that in this case,
if he had not initiated any action on the earlier cause of action. Yes.
Lordship.
Heard Mr. So-and-so learned counsel appearing for the petitioner, none appears for the respondents on call. Matter has been pending before this court since the year 2011. The grievance of the petitioner in this present criminal revision petition is the order dated 29/8/2011 passed by the learned JMFC, Gauhati, wherein it was held as follows. You will take from where is that order? You will take from page 25. This pencil mark portion, Thereafter, you will start at A on page 25 and you will take up to A on page 26. The learned counsel for the petitioner has submitted that the fact situation in the case of Krishna Export and others and Sadanand Bhadran versus others were different from the present case in as much as in the two cases referred to by the learned JMFC, no action had been initiated after the first check had bounced.
Yes.
And no notices had been given to the issuer of the check. Full stop. The learned counsel for the petitioner has drawn our attention to the case of Kamlesh Kumar versus State of Bihar and another.
Yes, sir.
To impress that once appropriate steps by issuing a legal notice had been taken on the first time when the check is bounced, and if the check is presented again at the request of the issuer of the check, a second cause of action would arise in favor of the holder of the check. Full stop. We have gone through the judgments referred to in the order of the learned JMFC and also the orders passed in Kamlesh Kumar versus State of Bihar and another reported in 2014 to SCC 424, and we are of the view that the facts in the present case are more similar to the facts of Kamlesh Kumar Supra rather than the facts of Krishna Export and others and Sadanand Bhadran referred to by the learned JMFC in the order dated 29/8/2011. In such view of the matter, the order dated 29/8/2011 passed by the learned JMFC in complaint case number
Complaint case number
79 of
797 of 2009, Lordship.
797 of 2007.
797C, Lordship.
797 উপর হলকে সি এটা থাকে under section 138 of the Negotiable Instrument Act is interfered with. The matter is remanded back to the learned trial court to take a first decision on the issue in view of the observation made herein above. We'll stop. The learned JMFC shall issue notice to the opposite party before taking a view in the matter. We'll stop. Criminal division petition accordingly disposed of.
I need to mention, I'm appearing on behalf of Miss S.K. Nargis, learned counsel for the appellant, Lordship.
But we have heard you.
Lordship.
We have heard you.
Yes.
What is your name?
My name is Abhijit Chaudhary, Lordship. A. Chaudhary.
Mr. A. Chaudhary. We have heard Mr. A. Chaudhary, learned counsel, appearing on behalf of Mr. S. Nargis. S.K. Nargis, learned counsel for the petition. এটা একদম উপর দিব, হ্যাঁ?
I crave indulgence from your lord.
Yes, yes.
My lord, item number 39, my lord, if the party will be after half an hour, after.
We are usually here till 4:45. If you are here, we can do it. If you want a date, we can give it.
My lord, my opposite party appellant is also here, petitioner is also here. So this may be fixed for another day, man.
When do you want it?
26th or 28th of March. February, March.
March.
Yes.
28th we cannot give you. 26th we can give you.
Yes, 26.
Place this at the consent of the learned counsel for the party, arrived at by the learned counsel for the parties. Place this matter again on 26th of March.
Yes.
Yes.
Item 35 and 36.
Yes.
My friend was supposed to give the instruction letter.
He will now show us a lot of difference in the duties. Yes.
It will develop.
On the last occasion, Lordship has raised a pointed query as to whether the incumbents holding a corresponding rank in other sub-organizations, whether or not equivalent to the petitioners, but when they exist concurrently in two sub-organizations have been given the benefit of 7 pay commission. Now, on being, my lord, communicated to my department, my lord. The department in turn has sought communications, my lord, to the, my lord, home department. And now
Who
it is-
represents the home department?
And now it is learned, my lord, that the home department in turn have sought for the relevant information from the office of the Director General of Police.
We are proposing a postal service here to ensure that these things go by email and come back by email. What is the pay scale of a particular cadre? How long does it take?
Because that is to be what my officers say, my lord, that it is for the administrative department, because the ROP as such does not makes any distinction. Therefore, since there was no recommendation from the pay commission, APRO does
For
not.
the others also, there was no recommendation.
Therefore, for others, if others have been given,
Who
the
appears?
administrative department concerned has my lord, has the inputs to meet up the query of this honorable court, whether other incumbents of the same rank has been given, because it is their personnel, my lord. They are the employer. So we are not the employer.
Same rank, if I'm.
And one another aspect of the matter, my lord, this may come as a good news, my lord. If Lordship may be pleased to peruse the first page of that bunch of instructions. My lord, the first and the second till fourth page, my lord, these are relevant. My lord, the new pay, 8th pay commission is, my lord, is going to, my lord, be constituted very soon. And they can raise their grievances before the 8th pay commission.
We'll settle the grievances for the 7th pay commission. 8th pay commission is a new cause of action where we will again argue the same issues.
Because we have taken a definite stand. Our stand is plain and simple. That, my lord, there was no recommendation from the pay commission, so therefore we could not accede to the claim, my lord, made by the writ petitioners. Number one.
Therefore, all we needed to know was whether it has been given to other persons who were not recommended.
That can only.
Where is that?
lord.
If GA Assam is not interested in participating in the matter, then it will be difficult for them. Item number 35 to 46.
All other subjects, my lord, in the cadre of my lord, Havildar to sub-inspector, my lord. Only in the river police, my lord, there were posts. In the other subjects, my lord, there are no posts in that cadre. The river police has been merged
into
the parent department. Now there is no river police existing. In 2021, it has been merged. So they are getting the salary as the 7th pay has given. Only the APRO, the person who is APRO, they are not getting. The other persons they are getting. The river police, they were having the cadre in like.
Who was appearing for the GA for the home department on the last?
On the last occasion, you Sharma had appeared.
Scroll you. We'll take it up after some time, Mr. Bob. Give us 5 minutes more. We'll await them.
Though not having energy.
Huh?
Though not having energy, I will wait, madam.
Your lack of energy is attributable to something, and our lack of energy is also attributable to another source.
My lord.
We are seldom in the habit of taking 2 or 3 breaks, but we have to take those breaks because our throat is not allowing us to sit for a long time. 5 minutes more. Let us see if we can bring a quietus to the issue. Yes, sir.
Hey, please, Your Lord.
May I please your lordship?
Have you seen the name of the appellant? No. Yes. Tell us. His name is Bullet.
I'm appearing on behalf of RB Board Lordship, the informant respondent number 2. She's not well, Lordship, so selected.
What is your ground of appeal?
Sir, my ground of appeal is that it is uncooperative and inconsistent. Uncooperative and inconsistent. The petitioner has been imprisonment. In imprisonment. He is convicted.
It is not supported by medical, as well as her 164 statement and the statement made before the trial judge does not match. There are discrepancies.
The man is in jail.
Yes, Lord.
Yes, when would the
That's it. As well as the age of the victim is disputed here.
how? Show us there.
That's it, the medical, Lord.
What medical? There must be have been some document to show.
Okay, there is no other documents, okay, only the medical on relying on the, because nothing has been seized about the age of the girl.
Eh?
And lordship, the medical, lordship, the statement of.
No, the medical will come in only if there are no other documents.
Yes, lordship.
First, show us that she was studying in some school. Any document to that effect?
Lordship, I will point to the judgment, lordship, judgment, there exhibit, lordship.
Hi, exhibit. What are the exhibits?
Exhibits are, one is the seizure list, lordship, exhibit 1, then the medical examination revised, case map, FSL report, charge sheet. Lordship, there is no other documents to show the age of the victim.
So, hey, do so. TCR concern. Hmm. Is that how it is to be taken, that there is nothing to show that she is not above 18, so I will presume? Can that be the law? That is what the magistrate has done, the trial court has done. As such, there is no evidence before me to suggest that at the time of the alleged victim incident, the victim was not below 18 years. So the presumption is to be that it is a minor.
For that lordship, this doctor was cross-examined.
Maybe.
Molar teeth lordship, that was
Done only when nothing else is available, is it not? That is what we are trying to say. See. এই জি আছামৰ কোনোবা আহিলে মাতি দিব হা কেছটো। Can you find out anything from this? Caesar list, anything? Hmm? It's 13 to 17 is a huge gap. Do you have the evidence and all with you?
Yes, Lordship.
Huh?
Yes, Lordship.
Have you gone through it to find out if anything to show that she was studying in a school, some birth certificate seized?
I only have part.
Huh?
Only have the part of evidence, not the whole.
Hmm?
Only the statements. Lordship.
She must have made a statement before the. নাই কোনো GS আমার? Huh? Huh? কাপড় আছে ওখানে। Yes, and what are the contradictions?
Lordship, I want to say, go to the statement of the informant. Very interestingly, the informant, when he was crossed, Lordship, informant, Lordship, PW2, Lordship, as translated copy, Lordship. Lordship, PW2 is a hearsay witness to this case, Lordship. And in his cross-examination, he has clearly stated that I do not know what is written in the Azehar. Lordship, I was told by my mother that the accused person has taken Pallavi by holding her hand to his house. I met Pallavi. This is very important, Lordship. I met Pallavi after filing the Azehar. Pallavi told me that an accused person tried to do bad work. She kicked me and ran away. I did not ask Pallavi if the accused person could commit bad work or not. Here, the important part is that the informant does not know about the incident. He has directly lodged an FIR, and he does not know about the contents of the FIR.
Okay. Yes, when will she be available? Any date. Today is any date she is not available. Give us a date when she will be available. Huh? Mr. Sharma, I fail to find any statement whether she ever attended school or not, whether she had a birth certificate or not. No inquiry or no investigation on that line. Nothing is there. Now, if there had been some statement that because she is not in school, they do not have a so-and-so, therefore we'll go only by the medical statement. That's a different issue. But when no attempts are made in the investigation to find out the actual age, then the entire initiation of the prosecution may fail. Some document to show that there is nothing. Now then why start up a POCSO case when you have nothing in hand except one statement? It could have been a case of simple rape. If it is a case of simple rape, then the presumption of guilt goes. Therefore, the accused may be at a better footing. Is it not? How do they start a POCSO case without anything? Because the medical has to be, she has to be sent to medical, in our understanding, after the FIR is lodged as a POCSO case. Now, how did you presume POCSO? In the absence of anything and everything, how do you presume it to the detriment of an accused? Innocent till proved guilty. So we confiscated a birth certificate, maybe false, maybe correct, we don't know. We have a school certificate, maybe false, maybe correct, we don't know. Something. 16th of March. Ms. R.V. Bora is not available. Ms. R.V. Bora, Learned Counsel, paying for the respondent number 2 is not available today. List again on the 16th of March.
If possible on.
Huh? 5th of March. 5th of March, we have too many cases. On 5th of March, due to paucity of time, it will go to 16th of March. So why not 16th of March already? Book a seat. It might be password to my book.
Obligations.
Mr. Ayat Sekia, Learned Counsel, paying for the petitioner. Mr. R. Borpuja, Learned Standing Counsel for the Finance Department, has produced the instructions from the department which refers to the information being sought for from the Department of Home, from the Home Department, regarding the query raised by the court. Unfortunately, there is no representation from the Home Department today, huh?
Two documents are there in the record. Entire stand of the Home Department is reflected in those.
We are not on that. We require a certain information. That information is not before us. They could have shown us those two documents. We could have asked Mr. Borpujari something on that, and we could have decided the matter today. Their absence, we cannot even refer to their documents. They'll come back and say we were absent, sir. Unfortunately, there is no representation on part of the Home Department today. Full stop. List this matter again on the 5th of March.
Can it be after 23rd?
Huh?
Can it be after 23rd March? After Eid?
After 23rd March. After on you pick at it 25th. Matter shall not be treated as part-heard. We are releasing it from the part-heard because we cannot carry it more than 1 month. A hearing.
Then on 5th, on 5th.
Huh?
Then on 5th.
We passed it. We have given a date.
On 5th March, what we have released this matter.
Huh?
At the matter, it may not be released. On 5th of March, lawsuit take.
Hmm?
On 5th of March.
Is it to convenience, Mr. Sekia? At all times.
That's why lawsuit convenience.
Can it be a convenience at all times? Your convenience, my convenience. They are not present. We want to fix it in the matter on a certain date. You choose a different date. Then we again accommodate you. We did not accommodate the case earlier. We said 5th is too full for us. We kept this vacant. And then you wanted 23rd, 25th. So be it.
5th of March. 5th of March.
List again on the 5th of March. Yes. Something short we can finish.
Lordship.
Item 38.
38, Lordship.
Anything short we can finish. Tell us.
No, it is a conviction and sentence for to undergo 10 years for the offense 376. Lordship. For the offense under section 376. Round.
All parties here.
Yes, all parties.
You are representing, madam? Okay.
Mainly 4 grounds, Lordship. Unexplained delay in lodging the FIR. 5 months delay in lodging the FIR. Then material contradiction. IO has not been examined. Material contradiction of the deposition of PW1 LS victim. IO has not been examined. So prejudice is caused. And another thing, no witness from the place of occurrence. 4 witnesses have been examined.
In a
Informant-
376 matter, you are talking of witnesses from the place of occurrences.
Yes, it is because it has been alleged that at the in the house of the accused, the occurrence took place.
Huh.
And in that house, the aunt of the victim, that is the wife of appellant, her daughter of similar age, and one son is there. The allegation is that
Or at the time of the incident.
yes,
At the time of the incident.
no, in that house,
Usually.
in that house, but incident was alleged to be at night, and she was initially allowed to sleep with her younger brother. That is the son of this appellant. And her statement is at night, the son left, and then father entered, the appellant. This is the story. And 5 months, there is no allegation, no FIR. After 5 months, and the allegation is that the FIR, it does not say it rape. Whatever it is, it does not say rape. Allegation in the FIR, it says prohibition. FIR I have annexed with the appeal memo also. The vernacular is at page 15 of the appeal memo.
FIR says that it was cohabitation, but ultimately what came to be proved is that it was without her consent.
According to the learned trial court, without her consent, as posted. What I beg to submit is that statement in her depositions are contradictions. And that contradictions we could not confront with the IO because of non-examination of the IO. That caused prejudice.
Okay.
Prejudice to the accused person. And unexplained delay in lodging FIR. There is no explanation why after 5 months this FIR was lodged. It is fatal to the prosecution case. It is, I will submit, rely upon decision. It is fatal to the prosecution case if it is not explained.
In cases of sexual assault.
In any case, it may be benefit.
No, we'll have to also go by the facts of the case in which the court says that it is fatal.
Yes,
he took money from my pocket, fatal. He boxed me in the ears, fatal. He took away my vehicle, fatal. He called me by bad names, fatal. He tried to stab me, fatal. He raped me, still fatal.
Now, why 5 months?
He did things to me which he should have not done, and if I say to the society, I was embarrassed, still fatal.
No, why 5 months? 5 months. Mother is there. 5 months. After 5 months, it took, and there is, they have a allegation that there was a pregnancy. It was terminated. It was terminated.
What was your story?
Nothing.
Because the petitioner was allegedly at your house prior to their 5 months.
Yes, yes.
So there must be some story behind the pregnancy.
I think they did not.
She had an affair with someone.
Denial.
Complete denial.
Denial.
Complete denial is.
First, he has to prove that she, at that night, when she, at least son was sleeping with her, she was not sleeping with appellant's wife and daughter. It has also to be proved. Why in the 2-room house or?
Yes, I am not being
Examined.
and cross-examined.
May not be fatal lordship. They will have to show what was the prejudice that has been caused.
They say that the investigation was wrong. What could be the prejudice is another thing, but if they say that the IO was not cross-examined.
Lordship, in all these cases, lordship, statement is enough. If that is shaky or it is not credible enough, then they have a case, lordship.
That is contradiction. That part is contradiction, which we could not confront with the IO.
Just because
No,
contradiction
no,
will
no.
not help.
Just a minute.
Yes.
You could not contradict the victim statement with the IO statement. Was
Yes,
the
that is
IO
to-
there at the time of
yes,
incident?
This is the procedural lordship. First, we shall have to take contradiction with the witness. Then it has to be confronted with the IO, with the is a previous statement. Otherwise, this contradiction is of no value.
When was it? 2019.
The other allegation is that in December 18, she went to the house of the appellant, where appellant, his wife, his daughter, and her son stays. Page 24, Lordship, or this. Page 23, 24 is
Now
the
we are reading up
deposition
to
of-
page 27.
Yes, there is also there. She continued to 15 to 20 stay 15 to 20. She continued to stay 15 to 20 days there.
In case you can convince us that there has been some prejudice regarding the IO, we'll remand the matter back for calling of the IO, but that is all.
There is prejudice, Lordship, page 24, which is quote unquote her statement.
Where?
Page 20, page 24. Cross
24.
It is not a fact that I did not state before the police.
It is not a fact that I did not state before the police.
Then quote unquote. This is totally contradiction. It was not in her 161 statement, which you could not confront with the police. And the second paragraph also.
Then?
This is the entire story. This is a new story she stated in the court.
It is not a fact that I did not state before the police. So I stated before the police.
She will deny. This is why it is recorded. This contradiction. This part, she deposed in the court. We suggested that because it was contradiction according to the 161 statement, we suggested that you did not state before police. So she denies. So it is recorded like this. And that part will be proved when we will be able to confront with this part with the IO.
Yes, what do you say, Mr. Sharma?
If this fact relates to her
Huh?
stay at the accused house, which has been corroborated
This
by
is
the
the
other
important.
witness-
By the?
other witnesses.
Who
Lordship.
witness? Mother and father? They were in their house. How can they corroborate? They are hearsay evidence. Only these witness.
My lord, after going through the evidence on record, your lordship will find that my lord, learned lord for rightly pass the order. Because my lord, kindly come to page number 23, my lord, and excerpt 3. That is my lord victim's statement. PW1, she was examined as PW. PW 123, page number, my lord. On last line, first para, my lord, the accused person gagged my mouth by his hand and raped me, and thereafter he left the room. And only one witness is sufficient to prove the fact, my lord. Victim's evidence is sufficient, my lord. So, my lord, my humble submission is that this, my lord, kindly appeal the order of the learned lower court, my lord.
We said this gagging part is lordship contradiction. It is there in page 24. It was put to her.
And 64 statement also recorded, my lord.
Then the accused gagged my mouth by his hand and raped me thereafter on the left. I may bring another decision, lordship, how contradiction has to be proved. Today I have brought this on delay and met this contradiction. Examination of IO. How contradiction has to be proved, and it will be, I think, clear. That is the decision.
The learned counsel for the petitioner desires to produce certain citations in support of this appeal. When can you have them? We'll list it on 17 March. On the 17th of March. List again on the 17th of March.
Oh, bless.
Oh, bless.
Sir. Yes.
Yes, challenge here is the proceeding of NIA clause. The other side is not here.
Now, what is wrong with this?
Regarding the proceeding.
What is wrong with the order?
Order is also just there is no actually the only issue is that whether there was any legally enforceable debt on the part of
That is for a matter of trial. That is what the court has said. It's a matter of trial. We'll see if it's not a legally enforceable debt.
But apparently it is not a legally enforceable.
How?
So I will convince Lordship to take up.
Blank checks in question and admitted the signature of the state check, but she has declined to the fact that she took 2 lakhs. She has taken only 1 lakh. And she has returned 80,000. Except 20,000.
Her statement in the complaint petition is something different, Lordship.
What? No. Your admissions.
No, Lordship. We are not admitting the statement.
Your statement before the court that I took some money. I did not return it fully.
Yes.
I have to give some money.
Yes.
Checks are issued by me. I have signed them.
Yes.
Now, legally enforceable debt or not?
Yes. But they have stated as something different, Lordship, in
What
their
have they
complaint petition.
No, maybe.
That is why, Lordship, they have given a first statement, and according to Lordship, I may pray to Lordship initiate perjury proceeding.
Do that there. Do that there.
That is there.
Do that there. But whether their contradictions are enough or not, will this court now sit down and see all this?
If there is a Lordship apparent contradiction, if fact is there, if no case is maintainable, then Lordship can interfere.
What did they say?
In page 15, Lordship.
Now, what is their statement?
Page 15.
Huh?
I missed. Merit page 15, Lordship, para 2. Any other Lordship, I will
Postpone till? List again on? 19th of March.
Yes. Till the interim is there, that will.
Huh?
Interim is there, also, that will.
Interim order continues.
Yes. Now apply this.
There is an interim, there is an interim, your lordship. I'm only paying.
Well, so far as I'm concerned, I would be supporting him rather, although I'm on the other side, it will be one liner. At page 34, cognizance was taken without following section 223 of the BNSS. I concede. It should go back from that stage onwards. It should go back from that stage onwards. That's the law. He did not enjoy his stay. He should go back from that stage onwards. One liner submission. Nothing more. That's all. No, that's all.
Too short for me to pass an order today. When would you like to have it?
Tomorrow, first item. So that will be my stand. That will be my stand. Although I was there, I'm arguing. Cognizance was taken without following 223. Let the matter go back from its.
Ten, 12, 13, 16.
As your lordship.
Choose a date. 10, 12, 13, 16. Choose a date.
I give it to your lordship, but only that it again comes on the bottom of the list and then it rolls on. He enjoys the stay. And I'm nothing to say.
Some things are better not quoted. We'll have it on the 17th of March.
F2.
Huh? F2, make a mention. Make a mention. You said that you are conceding. Make a statement that you are conceding. Matter ends. Any court would be happy to take it up. Happy to help.
There's an interim, your lordship.
The interim order continues. List again on the 17th of March due to paucity of time.
Deep.